Good morning and welcome to the March 22nd, 2022 Virginia Marine Resources Commission hearing. My name is Justin Worrell. I'm the acting commissioner for the agency. We're going to begin this morning with the Pledge of Allegiance led by Mr. France, followed by an invocation from Mr. Tankard. Please rise.
Please turn and face the flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Lord, let us pray. As we come together today to do the work of the Commonwealth, we ask that our deliberations and decisions be honest and forthright. We give thanks for this commission, its dedicated staff, and brave Marine police. Finally, we pray for the Ukrainians as they boldly fight to preserve their democracy. For this, we pray. Amen.
Thank you, Mr. Tankard. Again, welcome to our public hearing this morning. If you are here to speak on any of the agenda items listed, you will have the opportunity. We will also have a public comment period that you'll be allowed to address any concerns that are not on the agenda. First thing this morning is the approval of the agenda. A question of our division chiefs, are there any changes or updates? No changes, no updates.
I move we approve the agenda as presented.
Okay. Motion by Mr. Zedron. Is there a second?
Second.
Okay. Motion and seconded to approve the agenda as submitted. All in favor, please say aye.
Aye.
Any opposition? Chair also votes aye. Thank you. I believe you also have the minutes of the previous meeting, the February Commission meeting minutes. Any questions, changes, updates?
I move we approve the minutes as presented.
Okay, hearing none. Motion by Mr. Zedron to approve the minutes. Is there a second?
So moved.
Second by Mr. Tankard. All in favor, please signify by saying aye.
Aye.
Chair also votes aye. Minutes are approved. This time we'll go ahead and swear in the staff and members of the Virginia Institute of Marine Science who may be testifying this morning. Please raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth? I do. Thank you very much. Please be seated. Now we have page 2 items. Mr. Owen, Chief of Habitat Management. Good morning.
Good morning, sir. We have 3 page 2 items. The City of Newport News is requesting authorization to install shoreline stabilization structures with clean sand adjacent to River Park Farms at 105 City Farm Road along the Warwick River. In the City of Newport News, components include 2 170-foot offshore stone breakwaters, 1 150-foot riprap spur, and 10,000 cubic yards of clean sand fill sprigged with wetland, beach, and backshore plantings to create 950 linear feet of living shoreline. Item 2B, the Department of Wildlife Resources is requesting authorization to anchor up to 3 barges from mid-March through mid-September annually to create up to 65,000 square feet of temporary bird nesting habitat in Hampton Roads adjacent to Fort Wold in the City of Hampton. This time a little differently. The anchors and the chains will be left behind after each annual mooring. They'll essentially just wrap the chain on top of the anchor and leave the anchor and chain behind. When they pull the barges out in September, they'll recover them with divers the next year. That's the difference between what you permitted in the past and this application. Naval Station Norfolk is requesting authorization to construct a concrete wharf and approximately 1,483 linear feet of replacement steel bulkheading adjacent to Pier 3 and the Elizabeth River in the city of Norfolk. The new wall will be a line of 8.5 feet channelward of the deteriorating bulkhead on the western facing reach and 4 feet channelward on its north facing reach. Existing scour holes under the proposed concrete platform will be filled with VDOT number 1 stone.
Thank you, Mr. Owen. Any questions for Mr. Owen or his staff? Mr. Zedron?
Item B here, when these anchors are left, are they going to be lighted so that people don't run into them at nighttime?
They will be submerged. I'll have to ask either Ben Nettleton or David Norris from DWR what depth of water would be over them at low tide.
So the anchors will be left, the chains will be put.
Mr. Norris, please come forward.
So,
And please state your name for the record.
David Norris, Department of Wildlife Resources.
Raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth?
So bad I do.
Go ahead.
So the anchors will be left in place. The chains will actually be underwater on top of the anchor, just coiled on top of the anchor.
Okay.
And then they'll be marked with the buoy.
Okay.
Yeah, but
And what depth?
How deep?
Is the water there, I believe, is from 12 to 15 feet deep.
So what I'm interested in, there've been, since the construction on the bridge here, there've been some boats at nighttime hitting the buoys without lights and damaging the boats. So the question goes to is how deep is this going to be under with the water?
So the barge, they'll be on the bottom, obviously, so they're 12 to 15 feet deep.
Okay.
that'll be from October through the following, is it March?
Mid-March.
Mid-March, before the barges are brought back in. They're required to be pulled out, but they're gonna leave the anchor chain.
The anchor's in place. It makes our setup and takedown so much easier and cheaper, truthfully.
Thank you. Any further questions for Mr. Norris? Thank you, sir.
Thank you.
Any other questions regarding the page 2 items? This is a public hearing. Anyone, would they like to speak regarding the page 2 items, either pro or con? Okay, hearing none, the page 2 items are before the commission for approval.
Move to approve page 2 items.
Motion made by Mr. France. Is there a second?
Second.
Second by Mr. Ballard. All in favor, please signify by saying aye.
Aye.
Chair also votes aye. Any opposition? Okay, the page 2 items are approved. Thank you, Mr. Owen. We have no consent agenda items, correct? Okay. Ms. Block, any need for a closed meeting this morning?
No, sir.
Okay. Now we come to our law enforcement license status review. Good morning, Colonel Rogers.
Good morning, Commissioner and Commissioners. I'm not sure if the TV screens are working there.
Screens aren't up yet. There we go.
So this is a license status review. The offender is Timothy Lindsay. So here before you, Timothy Lindsay has some new convictions, working while revoked on June 9th, 2021. He was convicted on August 30th, 2021. He was working while revoked on June 4th, 2021, and convicted on August 30th, 2021, and again on April 5th, 2021, and convicted on August 30th, 2021. With the first offense on June 9th, well, actually, let me start with the April 5th offense. Investigator Price observed a fishing vessel, Mrs. Leslie, working off the Dominion Coal Terminal in the James River, which is a body of water surrounding the jurisdiction of Newport News in Virginia. Investigator Price was able to video and take still photographs of Lindsay retrieving crab pots from the water and assisting the commercial harvest of blue crabs. Lindsay is a mate of the fishing vessel, Mrs. Leslie, which is owned and captained by Ken Diggs Sr. The investigator observed Lindsay on and off for approximately 11:58 a.m. until the boat docked at 2:52 p.m. in the afternoon. On see, the next one would be June 9th. June 9th. MPO Elliott was on routine patrol while he observed the fishing vessel Mrs. Leslie crabbing in the James River, which is the vicinity of Craney Island in Newport News. The officer actually made contact with Mrs. Leslie vessel and observed Lindsay actively retrieving a crab pot from the water, shaking the crabs from the pot into a container, then rebaiting the pot. Lindsay then set the crab pot on the gunwale of the vessel and wiped the sweat from his head. Furthermore, Lindsay returned the baited crab pot into the water. This was also observed through audio and video by the officer. At that time, the officer made contact with Investigator Price, who was investigating the matter. And then on June 9th, again, Investigator Price observed the same fishing vessel, Mrs. Leslie, crabbing in the James River in the vicinity of Craney Island. Investigator Price was able to video and take still photographs of Lindsay retrieving crab pots from the water and assisting in the commercial harvest of blue crabs. This was observed from approximately 6:55 a.m. until 12:01 p.m. in the afternoon. So Mr. Lindsay first appeared before the commission as a natural resource offender during the March 2021 commission meeting. The commission decided to revoke all Mr. Lindsay's licenses and privileges for a period of 1 year, beginning March 23rd, 2021 through to today, March 22nd, 2022, and place Mr. Lindsay on a subsequent probation for 2 years, beginning March 23rd, 2022 through March 22, 2024, owing to the conviction of the 4 oyster violations. Here is his previous convictions. I'll let you guys review over his previous convictions here real quickly. And this is his current 2021, 2020, and 2022 license and permits. So the guidelines for the sanction specify that 2 or more convictions crabbing without a license or without eligibility within a 2-year period should result in at least a 2-year revocation of all license and privileges. The guidelines suggest the commission to revoke all of Mr. licenses and privileges for a period of 2 years from the date of this commission meeting, March 22nd, 2022 through March 21, 2024. The Code of Virginia also allows the commission to prohibit the issuance, reissuance, or renewal of any of Mr. Lindsay's licenses during this revocation period and may take discretionary action concerning the potential of a civil penalty. And I'll go back, leave that up there for you guys. I will make note that on all 4 offenses in 2021, he was found guilty in the court of law. And I think he's represented by a lawyer as well.
Thank you, Colonel Rogers. Any questions for Colonel Rogers? No questions? Mr. Tankard?
When he's caught in this fashion, what's the demeanor of Mr. Lindsay?
I can't speak to the demeanor at the time of the offense because the officers aren't here. I can tell you that speaking with Mr. Lindsay this morning, he seems to be calm and understanding of the situation.
Thank you.
Mr. Ballard?
What was the notification when they're observing him taking pictures? Was he notified that day of the offense, or did he receive something in the mail?
So he wasn't notified those days of the offense. He was notified subsequently after that when he was served the charges, of the 3 charges at one time. I will make note that on March 24, 2021, he was personally served a letter from this agency regarding his revocation of his license, and he signed that letter. So he was aware, or should have been aware of the revocation.
Yes, Mr. Zedron.
So when you talked to him this morning or any other time, I mean, did anybody ever ask him why he continued to violate the law after he had these convictions?
I think with these situations, and even speaking with Mr. Lindsay this morning very briefly, this is just a matter of livelihood for him and other watermen, and it's just, he indicated in this conversation that he has no other means of income.
Thank you.
Mr. Ballard?
And how you revoke a license, so that's all fishing privileges, acting as a mate, fishing for croaker off a bridge, Can you explain that a little bit?
I'm actually
more
pull up
for me?
the verbiage here, I think is attached to this, because that's a good question. It was also posed to me just a few minutes ago. And I'll also defer to Kelsey as well for guidance. But the code defines term fishing to include all operations involving taking or catching marine organisms and transporting and preparing for market those marine organisms. In other words, a person whose fishing privileges have been revoked or forbidden from doing any work on board a fishing vessel that in any way pertains to the harvesting of marine organisms, preparing them for market or transporting them to a place of harvest to the land. Would be forbidden from driving a boat while the boat has gear in the water or while it has marine organisms on board, culling oysters, or assisting other crew members with the use of any gear.
So in other words, no commercial activity.
That would be my interpretation of it, yes.
Any other questions? Is Mr. Lindsay present?
Mr. Lindsay, may I approach?
Sure.
Good morning,
Good morning.
members of the commission. My name is Mike Ware.
Are you counsel for Mr.
I am
Lindsay?
counsel, and
Okay.
I do have the privilege of being here quite often.
Okay.
I know that they recognize me quite well. Mr. Lindsay, please, sir. We can swear him in, but may I proffer what I believe will be the most productive aspects of this matter?
Okay.
I've also spoke with the officer this morning. I've worked quite well with Officer Elliott and Officer Price in the past. I will tell you that this gentleman came to me, one of my clients has asked me to represent him in the matter. Unfortunately, he came to me later than sooner.
I'm sorry, and your name again?
It's Michael Ware.
Michael Ware, okay, thank you.
I'm sorry, sir. And it's nice to see you, Mr. Worrell. I've been knowing Mr. Bowman for a number of years. What has happened, and I think there's a lot of, as the board knows, there's a lot of conflicts. What Mr. Lindsay thought, and what I spoke to the officer about this morning, is that he could serve as a deckhand. If you look at all of these particular matters, he was assisting. In fact, the language says that he was assisting. He was not the captain, he was the mate. Also, if you look, his revocation was primarily focused on oysters. Culling of oysters was not properly done. This was crabbing. He believed that he could be a deckhand for crabbing because there has been instances in the past. And I can, in fact, when his was revoked, I played the meeting that particular time. It was done virtual. And there was the question about the fact that, does this revoke all of his licenses? Does it do this or the other? The watermen always don't understand the fact that the language, if you go from one conviction to three, the compounding of taking just the licenses for that particular aspect, say oystering, crabbing, or certain other matters, to where you can revoke all the licenses. I'm not making excuses for him. I don't think he's made any excuses. The one thing I will say that is kind of not to his benefit, and I don't think it's to the commission's benefit, is they watched this gentleman in April, they watched him on June 4th, they watched him on June 9th. Nobody told him, look, you can't do this. This is not what you're supposed to be doing. They go to a magistrate on June 28th, and they acquire 3 charges, and then they serve him in July. So if there was a concern, if you look at the matrix for 828.2.232, it talks about the damage that's been imposed upon the Commonwealth and the resources. If he's assisting in crabbing, he believes he's okay to assist in crabbing, and if he's actually perpetrating a real damage to the ecosystem, I think Price or Elliott should have come up to him and said, first time I've seen you, look, you can't be working on a boat, don't do it, and this is why. I'm not saying that the ignorance of the law gives him an excuse, but I'm saying I think it should be a two-way street in this regard. The irony of it is, this was scheduled in October, and now because of delays, the last time it was delayed, I don't know why, I just got a call from the commission. It has been pushed over to actually the anniversary date, the day he could go back to work. He has not had any problems since he got served those 3, but the 3 were basically the notice of the first. This is where you've become a foul. And so if you do impose a 2-year additional period, October would have been the time when it would have been imposed in the original schedule of the matter. Now we're basically almost 6 months out, and basically he's going to have to belabor that. I'm not going to argue the fact that he still has two-year probationary period that's active, even from the past rulings. All I'm saying is, I don't believe this gentleman actively tried to defeat the law or break the law. Criminal intent is an important aspect of the matter. I don't think it's here. The fact that he doesn't understand the system, he pled guilty to the first 4 charges. He accepted responsibility for that. He said he was on a boat when I confirmed with him that the captain was not calling properly, and he accepted the responsibility that it was his job as well, because everybody on the boat shares that responsibility. But with this particular matter, he doesn't believe that he's done anything. And candidly, he did tell the officer this morning, can I turn in my licenses? Can I go to work without my licenses? I don't know anything else. I'm 35 years old. I need to support my family. I don't know anything else. I can tell you, since he came to my office when this first came about, he has not been on a boat. A couple of the people that I know that he works with have made sure he's doing things on land, like repairing crab pots and those other kind of things to keep him occupied. I will also tell you, I mean, I've always been straight up with this commission. The fact that he has the convictions, the General District Court gives you the authority. I cannot take that away. Circuit Court out of Gloucester, the matter was appealed to Judge Shaw over there. He rejected the commission's ruling, went to the Court of Appeals, and they said the mere fact that the General District Court has found him guilty gives you jurisdiction to do what you want to do or feel is your pleasure. So I'm not here making any arguments in that regard. There is no legal argument that gets us here today, other than he lacks the mens rea, I believe, to properly be before the board. And if you have any questions, he's here to answer. He's sworn.
Mr. Lindsay, would you like to add to that?
No, sir.
Well, let's
Swear.
raise your right hand. Let's swear you in. You swear to tell the truth, the whole truth, and nothing but the truth?
Yes, sir, I did.
Okay, go ahead.
When I was never told during my first commission meeting. I know, reading the paper, it says all commercial. I understood that, but I like I said, I wasn't trying to break the law. I wasn't trying to go against anything y'all had said. I didn't know I was in the wrong, and Officer Elliott, Officer Price, I've known them for 7 or 8 years, and nobody ever offered to tell me that I wasn't allowed to be on the boat, other than the 3 summonses I received.
Okay, thank you. Any questions for Mr. Ware or Mr. Lindsay? Mr. Zedron?
A minute ago, I asked Colonel Rogers here, did he talk to you this morning, and did he ask you why you continued to do what you did in sight of the fact that you were on probation? And I recall his testimony as you saying that you did it because you had to earn a living, not that you didn't know that it was illegal. Did you tell him that that's what you said?
Oh, no, sir.
I was part of the conversation. It was that he didn't realize it, and that I'm 35 years old and I don't know any other way to make a living. I don't think it was in spite of.
No, it wasn't in spite. Absolutely not. I never went there specifically for the fact that to break the law or to do wrong. If they would never issued the summonses, I would be back to work today. I got off the boat as soon as I was informed that I wasn't allowed to be there. I was totally ignorant on that part.
Okay, thank you.
Mr. France?
Mr. Lindsay, before your licenses were revoked, what licenses did you possess?
Commercial crab pot license, 300 pot, the oyster, and the oyster license.
So, Mr. Lindsay, your last revocation, that hearing was virtual?
Yes, sir.
Okay, and did you also receive written notice of the findings?
The day after the virtual meeting, an officer came down to the boat where I was working and asked me to come. He watched me come off the boat and sign the paper. And even then, when I signed the paper to letting me know that I was revoked, even then, I was never told that I'm not supposed to be on that boat. And like I said, I mean, I continued to work out of ignorance. I didn't know that I wasn't allowed to be there. I had known 2 or 3 people before me that have had their license revoked, and they were allowed to keep crabbing, keep fishing. They just couldn't oyster. Like I said, I was ignorant to that fact. I wasn't trying to break the law or go against anything y'all had said.
And the previous oyster violations, were you a mate? Were you?
Yes, sir.
Okay. Mr. France?
When does your, the revocation you're on now end?
Today.
Today?
Yes, sir.
Today. And he has a 2-year probationary period thereafter, I believe, with your motion.
I just want to be able to even just work as a deckhand, and like I said, I'm 35 years old, I've never done any other job. It's not like my business just closed down and I can go do something, you know, in the same field of work. I don't have that opportunity, and I don't have any further education other than high school, and I don't know how to do anything else.
So just to clarify, if there are no other questions, when your license was previously revoked, you thought you could still perform deckhand mate
Yes, sir.
duties?
Yes, sir.
Okay, and you're saying that you never had any conversation with anyone telling you couldn't?
No, sir.
Okay, and then they were oyster violations?
Yes, sir.
Okay.
And the first time I was notified I couldn't be on the boat was the 3 summonses Officer Price handed me July the 1st.
Okay. Any
If I
other
may
questions?
have, if I may have one thing.
Sure.
He's not out there like in a hidden mode. He knows the officers are around him. He's coming to the docks with the goods. They're just not being sold with his number. The oysters aren't tagged with his number. He's worked as a deckhand. If it was something that he believed was a violation, clearly the officers are seeing him on the boat. They're seeing him return to the dock. It's not something that he could easily hide. It's not like he's out there towing for oysters at midnight or something of that nature. I believe we set the stage of what we have to offer. I will concede that it's not something that we have a strong or maybe even a beneficial legal argument because of the way, where he finds himself now. He pled guilty to the first 4 and was found guilty of the second 3. That boat has sailed. So it's clearly before you all about whether you believe this gentleman should be imposed more. He does still have the continuation period.
Mr. France?
Yeah, Mr. Lindsay, did you work as a deckhand in any other capacity?
What do you mean by that, sir?
I mean, helping in any other times than these that we're talking about today?
Oh, no, sir. As soon as Officer Price issued and informed me that I couldn't be on the boat, I hadn't been back on the boat since then.
Question for Colonel Rogers. Do you know, were there any problems with the vessels or whoever was captain of the vessels on which he was working previously?
None stated, none provided, no, sir.
Okay, so his previous violations, they were specifically for him?
Correct.
Okay.
I got a question.
Mr. Zedron?
When he was observed the first, we're talking about these convictions he's got right now, the first time, why don't we notify him right away or go issue him a summons? You know, why would we wait months to sort of build up a case?
You know, full transparency, I think it's a great question, Mr. Zedron, of why we didn't charge him at the first offense for notification. That is something that I'm looking at from, you know, from a division perspective. So in terms of why the officers waited and observed him on 3 different occasions, we're still getting to the bottom of that, but that's a good question.
Okay, thank you. Anything further,
No,
Mr.
sir.
Ware,
We
or
appreciate
Mr.
your-
Lindsay?
We appreciate your consideration.
Okay, any other questions or comments from the commission? Okay, so we have a recommendation for a 2-year revocation. Is there a motion to accept that recommendation?
Yeah, I would come up with something a little different. You know, I can understand Mr. Lindsay's situation with everything was virtual. And from what I'm reading here, it is kind of difficult to understand about being a deckhand. And I would let his revocation end like it did, can add another year's probation, 3 years probation.
Okay, is that a motion?
That's the motion.
So we have a motion for a 3-year probation for these violations instead of a 2-year license revocation. Is there a second to the motion? Mr. Ballard with the second. Any other discussion? There being no discussion, all in favor of the motion, please signify by saying aye.
Aye.
Chair also votes aye. Any opposition? Okay, Mr. Lindsay, you have a 3-year probation now. Please be very careful.
So, let me get this straight.
I'll explain.
Okay, I just don't want to run into the same problem again, sir.
Understood. If you have any questions, please contact our law enforcement.
We'll take care of them, and we do appreciate it.
Thank y'all very much.
Thank
Thank
you
you.
again, good to see you. Nice to
Thank
see you,
you.
Mr. Wolf.
Thank you. Thank you, Colonel Rogers. Okay. Now we will come back to habitat management cases. Item 6, Chesapeake Landing Homes Association. Good morning, Mr. Nettleton.
Good morning, members of the commission. Let me pull this out here. Let's see. All right, so my first case this morning is from Chesapeake Landing Homes Association. They've applied to construct a 20-foot wide by 220 linear foot stone groin directly adjacent to an existing deteriorated timber groin at property 17 Thimble Shoals Court, which is city parcel 120006617, adjacent to the Chesapeake Bay in the city of Hampton. This requires both a dune and beaches and a subaqueous permit from the commission, as the city of Hampton has not enacted the dunes and beach ordinance. So the location of this is not too far from here. It's just a walk up the beach. You'll see down here is where we're located at the Fort Monroe currently. This is right at the boundary of the Fort Monroe, the federal property, and the then Chesapeake Landings Homes Association, which is here. This is the Buckrow Fishing Pier. So there's the U.S. government property fence right there, and the groin is basically directly adjacent to that fence. Zoomed in aerial from the city shows again that structure. The larger structure you see here is the no trespassing fence from the old Army base, and then the groin is this smaller structure that is largely failed just to the south. This is the another rock groin that was replaced under 2016 permit. This is kind of an older aerial, but you'll see that in a second. So this is the plan view drawing, again showing the homeowners association lots, and then this parcel that is in question is entirely the community beach for it. The mean low water line is here. In this case, since you're acting as a beach authority, your jurisdiction is the entirety of this lot because the dune is back here against the bulkhead. The groin will then extend 220 linear feet from that bulkhead down and take a turn right about mean low water, and that will kind of use to be collecting the sand as it moves from the north to south in the longshore current in that area. Again, this groin that's there that you saw in the aerial a minute ago was permitted under 2016-1200. That was in November of 2016. Another cross-section of the groin shows again that existing bulkhead, the groin then extending out and taking that turn towards the north to kind of help collect the sand there. It is 220 linear feet in its entirety. 186 feet of that is in the beach, and 34 feet of that is out past mean low water. In the cross profile, you can see down here in section B, the mean high water elevation is 2.5 feet, and the top of the groin is at 2 feet, so it will be submerged at high tide with wave breaking and then exposed at low tide. So this is the site conditions of the existing timber groin. You can see it's pretty well failed. There's some old concrete and stuff that was placed long ago. This is looking out towards the east, towards the open bay, and this does look right out kind of between the Chesapeake Bay Bridge Tunnel, so it does really have ocean fetch in this area. Looking up towards the land then, this is VIM scientist Emily Hine, and you can see the existing groin kind of tapers and it becomes buried into the dune that's kind of been rebuilding here. The homeowners association has been doing some restoration in that area. A closer look into that shows that the timber groin is then buried, and the existing bulkhead, which was referenced running along the homes, is buried. So we talked to the homeowners association about this and the agent, and we do recommend then that the groin be buried into the dune as to not, interfere with the sand movements and dune vegetation that's building up there. And you'll see that as a special condition. So after that discussion that came in, with notes that the applicant during construction will protect the existing planted dune from erosion, the stone will be tapered to a height below the terminus of the existing bulkhead, so the stone will not be higher than this existing bulkhead back here. And then they will do some repair work on the dunes, which is exempt from permitting, just some planting additional vegetation on some of those lots. So again, the impacts, the subaqueous portion of the project is 26 linear feet. There'll be 520 square foot footprint of that will be converted to intertidal riprap, which will serve as oyster habitat. For the jurisdictional beach, there's 2,680 square feet of beach loss that will be placed above mean high water. 1,200 square feet will be converted to intertidal riprap. Again, that stone grind will taper at the western end and be buried. And then any temporary impacts from construction equipment and staging on a vacant lot will occur on a vacant lot directly adjacent to the site. So the rock will come in from the upland. They have a good access there. And in this case, the applicant does do the construction as he is licensed that way. So after review, staff finds that the project meets the criteria in both 28.2.1205 and 28.2.1403.10A of the Code of Virginia. We do recommend approval of this project as proposed with the following special condition. Impacted dune areas shall be restored after construction. Dune restoration should match that of the adjacent dune and then be planted with appropriate dune vegetation. If rock is placed in an excavated dune area, the dune shall be restored over the rock after construction. And that is in line with the VIM's comments and recommendations we received on this project. And I know the applicant is here, and I'm available for any questions.
Thank you, Mr. Nettleton. Any questions for staff? Is the applicant present and would like to comment? Please come forward. Please identify yourself and raise your right hand.
Joel Petrie.
Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Go forward.
Mr. Chairman and members of the commission, appreciate you hearing our application, and I'm just here to answer any questions you might have.
Okay. Any questions for the applicant? Okay, thank you, sir. I don't have any questions.
Thank you.
Thank you, Ben. Okay, we have a recommendation to approve the project as submitted with a condition. The chair will entertain a motion. Motion made by Mr. Minor to approve. Is there a second? Second by Mr. Tankard. All in favor, please signify by saying aye.
Aye.
Any opposition? The chair also votes aye. Thank you, Mr. Nettleton. The project is approved.
Thank you.
Okay, moving along, we now have item number 7, Carl Westfall and Mary Swift. Commission review of the appeal. Wetlands Board appeal. Mr. Nettleton, good morning again.
Hello again. I'll pull this one up here. Okay, well, that's pulling up again. As Justin mentioned, this is an on-the-record review of the Hampton Wetlands Board decision from their February 22nd meeting. They do meet the same day as the commission, so that can make long days for us staff, but we do it. So this is here. We received a timely appeal from the applicants, and again, this is the presentation I'll be showing you that was given by the Hampton City staff at the hearing. They chose to deny the permit, and then we'll get into the recommendation for you all. So these are the members of the Wetlands Board and their standard presentation. Forgot to advance, and there we go. So the Wetlands Board responsibility, I will read here because I think it's interesting, that the city reads, it's in fulfilling its responsibilities under this ordinance, the board shall preserve and prevent the spoliation and destruction of wetlands within its jurisdiction while accommodating necessary economic development in a manner consistent with wetlands preservation and any standards set by the Commonwealth, in addition to those identified in section 28.2-1308 of the Code of Virginia, as amended to ensure protection of shoreline and sensitive coastal habitats from sea level rise and coastal hazards, including the provisions of guidelines and minimum standards promulgated by the Commission pursuant to 28.2-1301 of the Code. So they did adopt minutes. The December 21st meeting was, the minutes of that meeting were part of this case. Those are included in your packet. And the background of this application, the site is at 12 Crowell Road. The application for a pier was originally submitted in 2020. That was a no permit necessary for the city of Hampton. We did issue a statutory authorization for that pier. There was no indication of any shoreline work at that time. The city became aware of work that was occurring beyond the scope of that permit and issued a notice to comply and stop work order on May 10th, 2021 for an unauthorized installation of revetment and a kayak launch. As you know, the new tidal wetlands guidelines were adopted by this commission on May 25th, 2021 at the public hearing. The violation hearing was heard by the city board on July 27th, 2021, and then the applicants were directed to submit an after-the-fact application. That application was 21-1396. It was heard and denied by the board at the August 24th, 2021 hearing. That decision was upheld by this commission at the following hearing in September. A second application was 21-2108, which was heard and denied by the board at the December 21st, 2021 meeting. Those are the minutes I referenced. That decision was not appealed. So, and then this is the third application, 220082. So the site of this location is just off the Mercury Boulevard Bridge. If you're driving to the west on Mercury Boulevard, it's off to your right, up in a cove of the Hampton River. An aerial view of that site shows, again, this is the Westfall and Swiss lot, and their shoreline along this area. They're back again in kind of a cove with a low-energy environment. The site, again, shows this is older aerials from the city of Hampton, the extent of the shoreline as it existed. This is the most up-to-date photo they had before the work was done. Again, you'll note the pier's not there, that is there now, but you can see there's extensive mudflat in front of the revetment that was enhanced. So this was from last summer in May when the initial violation occurred. This is the applicant and the city attorney. This is the kayak ramp that was placed unauthorized. Again, as you saw from the previous image, there was some extent of riprap, but new riprap was placed over top and to a further channelward extent. And this is standing on the dock that was authorized under 2020. Again, looking back to the additional shoreline, you can see the rip that was placed. I will note by the time the city got here, the work had pretty much been done, so there was not really any work to stop. So the after fact of the application has changed a little bit. Where we have now is we have a green riprap and a living shoreline proposed where that kayak ramp is. That kayak ramp will be removed. So looking at the plan view going, here is the kayak ramp. I'll draw your attention to the 18 by 8 by 16 foot area. You can see in the notes that's to be removed. We'll look at the living shoreline detail in a second. And then along the existing riprap, the lower portion where these little dots are is all to be planted, and the agent has indicated that they'll use 4 rows of wetland plants secured in the riprap, so those will be planted, and that's a concept they're calling green riprap, and is elements of a living shoreline in that area. There's a mulberry tree indicated here that'll be come in because you can see the drip line, so that area was not proposed for grading, and then there'll be CBPA buffer plants above our jurisdiction. The cross-section of it shows the existing rubble that was done before the work. That was basically capped with this new clean rock that was placed in. There was no filter cloth placed down. It was placed at a 2-to-1 slope, and again, you can see mean high water, and then 4 rows of plants that are secured among those rocks within the intertidal area. For the living shoreline area, I first want to orient you on this picture. The bottom here is the back of the sill, so this is the channelward area where mean low water is. Up here is the applicant's yard and the extent of the riprap. So what will happen is this kayak ramp will be removed, it will be filled with sand and then planted as a vegetated wetland. So you can see there's a total planting area of 216.5 square feet. 119 square feet of that is below mean high water, so it's in the intertidal area. 97.5 square feet of that is above mean high water, but still within the wetlands elevation. The cross-section of that shows, again, the sill, which will be placed out at mean low water. It's a 2-foot high sill with mean high water coming in at 2.4 feet. So this is the existing ramp grade at a 3-to-1 slope. The new slope here will be a 7-to-1 slope with clean sand placed, with Spartina alterniflora planted at the intertidal range and Spartina patens planted at the higher range. Again, the residual rubble will be the landward limits of this replanting area. So the City of Hampton's basis for recommendation on denying the permit had to do with this additional suitable area not proposed for living shoreline. The general area of the living shoreline here is what was just proposed. There's a pier, and this area was deemed by staff to be not suitable by living shoreline because of the drip line of the mulberry tree, which was desired to be preserved. So there's this area in question here. So the Commonwealth's criteria to grant a permit were reviewed by the staff. Again, these are your sections and code that you're aware of. I won't read through all of those, but they do remind the board that the new standards and regulations indicate that only living shoreline shall be permitted unless the best available science shows it is not suitable, in which case elements of living shoreline must be incorporated to the maximum extent possible. Again, reference the VMRC Tidal Wetlands Guidelines, Section 3, General Criteria D, that only living shorelines should be approved unless it is not suitable based upon the best available science. Section 3, Specific Criteria 1, repeats that statement. Section 3, Specific Criteria 3, says shoreline protection is authorized only if there is active detrimental erosion that cannot be controlled by living shoreline. Section 4, Minimum Standards 4, is that the board may only approve use of tidal wetlands if it conforms with Section 3. And in Section 4, again, the board shall utilize the best available science, and a site shall be deemed suitable for a living shoreline until proven otherwise by science. In Section 5, the best available science is to be determined by VIMS if it is in question. So there was a VIMS report that was in the record for all 3 of these applications. They basically just kind of updated their letters for the last one. citing that the living shoreline could achieve the project goals at the site based upon the best available science and existing conditions, which included the short fetch, shallow near-shore bathymetry, a large distance to upland structures, minimal boat wakes, and small storm waves. So if approved, staff did not recommend an in lieu fee of mitigation due to the provisions of on-site mitigation. So again, the staff basically countered here in bullet 3 that there was 81.9 square feet of mitigation that would be required for the impacts that were along the shoreline, 47.5 square feet of mudflat that was converted to riprap from that additional footprint channelward, and then 18 square feet within the kayak ramp, which of course would be converted to living shoreline. So the living shoreline area that would be new wetlands creation in the upland is 97.5 square feet. So that does exceed the City of Hampton's recommended replacement ratio of 1.25 ratio of 81.9 square feet. Just want to call that. The staff did recommend denial of this JPA, again, based on the 25 linear feet that the suitable area for living shoreline was not maximized. And if the board did grant the permit, they did have a list of standard 11 conditions that were included, again, mitigation not being one of those. So that concludes the hearing that the City of Hampton did. Again, we received a timely appeal by this. We notified the chairman and the city staff. The package and the minutes were included in your book item, so that's the full packet that the city got, and then the minutes were received as well. We reviewed those records and the current guidelines and law and considered suitability. We do believe that cost is a factor of suitability, and our recommendation thus is that the February 22nd, 2022 decision of the Hampton Wetlands Board be overturned. We believe that the decision to deny the application is unsupported by evidence on the record as a whole. The modified proposal meets the board's August 24th, 2021 direction to provide elements of a living shoreline to reduce the project cost. So that was the first time they heard this case. As such, staff recommends that the board be directed to issue the permit based on a revised drawing that more clearly shows the plan view drawing and the still in its entirety with tie-down dimensions taken from recoverable benchmarks.
Okay, thank you, Mr. Nettleton. Before we go any further, just want to remind everyone that this is a review, or it's an appeal of the record of a City Wetlands Board decision, and I'm going to ask Ms. Block to remind us of our duties and responsibilities.
So 28.2.13.13, the commission shall modify, remand, or reverse the decision of the Wetlands Board if the Wetlands Board, in reaching its decision, failed to fulfill its responsibilities under the Wetlands Zoning Ordinance, or the substantial rights of the appellant or the applicant have been prejudiced because the findings, conclusions, or decisions of the board are either in violation of constitutional provisions, in excess of statutory authority or jurisdiction, made upon unlawful procedure, affected by other error of law, unsupported by evidence on the record, considered as a whole, or arbitrary, capricious, or an abuse of discretion.
Thank you, Ms. Block. Any questions for Mr. Nettleton? Mr. Zedron.
Are you saying that the plan has been revised as it comes to us, or are you, when you talk about this plan, it was that the plan that was denied by the Hampton School?
Yeah, thank you for the clarification. That the plan has not been revised. What staff seeks here is a revision of this drawing so we can see the full extent of the sill rather than just a straight line. But the plan is not changed. The impacts would not change. There's no revision to that in what you have before you.
All right, so we're strictly reviewing their decision based on that plan.
Absolutely.
Thank you.
Any further questions for Mr. Nettleton? Ms. Lusk.
I guess I'm a little confused. When I remember when this came up before, and I recall that under the guidelines, the cost was not a factor. And so now your recommendation is based on cost. Could you clarify that?
Sure. Our recommendation based on the first hearing was that there was no living shoreline proposed at the time at all. So their argument was that the cost to do any living shoreline was the reason to just let them keep the riprap as proposed. So in this element, we do believe that they've met the board's expectations that elements of living shoreline be included to the maximum extent practicable, and that they are expending some costs. So we believe that since there is some living shoreline here, they've met the expectations of the board and the minimum standards.
Ms. Lusk.
So then your recommendation is based on the fact that you disagree, I guess, with Hampton City Wetlands Board, but you think that the elements of living shoreline that are now submitted, which are different than the original, are sufficient to satisfy the requirements.
That's correct. And the agent has, which is in your notes, provided testimony, which I assume he'll speak to, that there is a suitability issue within that 25-foot area, that a sill would not be stable on the offshore sediments, and that the cost and grading would be significant for that 25-foot area. So we do consider those to be factors of suitability that were not considered by the board.
Any further?
Repeat that, please, one
Mr.
more
Tanker.
time.
Sure. So the basis of this is that the agent has introduced testimony and extensive written records that the area of the city's recommended living shoreline would not be suitable because of the soft offshore sediments. A sill would sink, and Mr. Priest can speak more to that, and that the additional cost of grading back in that area because the slope is higher, the yard elevation is higher, would be prohibitive to a living shoreline. So we do agree that in that area they've then provided elements of the shoreline, which is what's required by law.
Any further questions for Mr. Nettleton? Ben, can you go back to your slide with the, or the city slide with the colored shoreline
which way that
sections,
was.
right there?
Yes.
So just so I'm clear, and maybe to help the commission, the blue dotted line is the drip line for the existing tree that they do not want to remove.
Correct. And so city staff concurred that this area would not be suitable for living shoreline due to the unavoidable impacts that would happen to that tree.
Okay.
So, and that drip line was then the basis for excluding that
Okay.
area.
The green area is what is proposed for the living shoreline,
That's correct. That's the footprint of the kayak ramp.
and that's where the unauthorized ramp will be removed,
Correct.
and the revetment and a living shoreline would be proposed right there.
Correct.
Okay. The area in yellow, it says additional suitable area not proposed. And make sure I'm asking this correctly without, I don't want to open the record in any way, but is that an area that the city felt should be more living shoreline? And if that wasn't discussed, that's fine, you don't have to answer that, but is that what I'm sort of reading into that?
That's absolutely correct. And as the applicant proposed it, that area would just be additional planting, similar to the rest of the tree area. So the city in their recommendation said that they recommend denial based upon not proposing a living shoreline where one would be suitable,
Okay.
which is that polygon here.
Okay, so my next question is, with this being modified for the second time, the numbers of created wetlands through the living shoreline, do those exceed the numbers of impact to the mudflat from the original installation?
Yes, they do. And in this case, the city did agree with that in their motion. They recommended that there not be any mitigation required because the on-site mitigation proposes 97.5 square feet of new wetlands area, which exceeds the needed mitigation amount. So to clarify, they are creating more uplands than were impacted, and the uplands they're creating are vegetated wetlands. The impacts that were conversions from non-vegetated wetlands to intertidal riprap.
So even though it was denied, the proposal included the creation of more wetlands than what was impacted from the original riprap?
That's correct.
Okay. All right, thank you. It's a little complicated. Any other questions for Mr. Nettleton? Okay. Are the applicants and/or their representative present? Please come forward. Are all three of you going to speak and present? All right, please come forward and we'll swear you in all at the same time. Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, who's going to go first?
Mr. Priest, I'll go first.
Please state your name for the record.
My name is Walter Priest, agent for the West Falls.
Good to see you, Mr. Priest.
Good to see you, Mr. Will. To Chairman, Commissioners, we're here today to appeal the decision of the Hampton Wetlands Board. We've been through this 3 times.
Mr. Priest, let me stop you 1 second, and just to clarify for the audience and for the commission, I'm going to ask Mr. Nettleton to let us know at any point, whether it's the applicant's agents or anyone testifying, if we start to steer away from the record. Again, this is a review of the Wetlands Board's record, so we don't want to get too far into any new arguments or new decisions or information.
Okay. All right. When it originally came up, the idea of the VIM's recommendation was that you could grade the bank back and build a living shoreline along the whole shoreline. We went to a contractor that has done this over and over again, very reputable person. I've worked with him for 10 or 15 years, maybe 20. He gave us a cost estimate for doing what the recommendation from VIMS was, and it came out to almost $69,000 to do what was requested. The cost of the riprap that's there was $12,000. So if you factor those, you take those numbers apart, using the original, using the estimate, and granted, this is a little overkill, but it costs like $20,000 to put this other 25 feet in here. And I think that's really high. But when the reason we proposed the living shoreline on the right side of the pier is because one of the Wetlands Board members suggested it. And that was the only real guidance we ever got from the Wetlands Board on how much is enough, what do we have to do. There was always, the reply was always, we have no guidance. Well, we're going to remove the boat ramp, and while we're doing that, the member said, why don't you just make this a living shoreline? And I said, we can do that. And in the second hearing, when the green riprap was denied, I proposed that, and they didn't say it was good enough, so it came back for the final time. I have a plan. It was cost effective to do it there because that's the lowest point on the shoreline. The slope is the flattest, and we'll already have to work in there. To go on the other side, the bank is higher, the slope is steeper, there's more material that you're going to have to excavate back into the yard. On the right side, we don't have to do any excavation. The bank is so high and so steep on the other side, it's going to require coming in and removing part of the yard in order to get the slope that you need to make the living shoreline stable. You got me all. The green riprap, we'll go back to the green riprap for a second. In the first hearing, the Wetlands Board one of the comments in the Wetlands Board in general was, come back with something that has some elements of a living shoreline in it, with no specifics. The living shoreline is a concept that's being promoted up in Maryland by the Fish and Wildlife Service to augment and increase the habitat value of stone structures. I have done it, it works, and it would increase both the habitat complexity and of the revetment and become a value added. Okay, I'd like to make a couple comments on the guidelines, because the guidelines were such an issue, and a lot of it was discussed in what you can do and what you can't do. And one of the big things was the factor was the cost. Our contention was it was excessively expensive. Now, I've read through the guidelines more than once, and the word cost is not in the guidelines. There is no line that says, thou shalt not consider cost. And if you say that, a reasonable person would assume that if there's nothing that says you can't, then you can. That's a reasonable person. So it is a factor. It would cost 2 or 3 times as much to do it as the similar section cost. Also, the guidelines are silent on the treatment of, of existing structures. The guidelines do not suggest in any way how existing structures should be treated. Under a permit requirement, you're required to maintain and repair the structure or remove it. This doesn't have a permit, but if you had a permit, you would be required to maintain it. And the way the guidelines are written now, you wouldn't be able to do that. You couldn't get a permit to do it, because if otherwise it required, you know, a living shoreline would be appropriate, they would have to do here. You have to rip out the existing structure and build a living shoreline. And that fails the reasonable man test. Also, they do not discriminate, the guidelines do not discriminate discriminate between already hardened shoreline, which this was. There was a rubble mound, there was a masonry rubble pile there on the shoreline. The guidelines don't, they treat that as the same if it was a marsh. In fact, when you go to the definition of a non-vegetated wetland in the guidelines, the definition of a natural, non-vegetated, hard surface wetland is gravel, cobble, or oyster reef. There is no mention of rock, revetments, rubble, anything. So the guidelines don't even consider it a natural wetland. Furthermore, you can't treat a natural shoreline versus a defended shoreline. In the VIM's guidance at the time, and it's still on their website as far as I know, when they talk about, they have a decision tree that says if you have this situation, you go here, and they have a whole decision tree for defended shorelines and a whole decision tree for undefended shorelines. They're drastically different on how you treat an undefended shoreline versus a defended shoreline. Even VIMS recognizes that there's a difference. I talked, the final thing is the natural wetland. In the definition of non-vegetated wetlands, rubble is not considered a natural wetland. It's not in the definition. Furthermore, in the minimum standards section at the end that changes everything from the standards that we had before, in the minimum standards apply to all ecological function of all natural tidal wetland communities. It also furthermore goes on to say in the next sentence, disturbances to any natural tidal wetland must now be crucially reviewed in compliance with work that we recognize the intrinsic value of these wetlands. It's not considered a natural wetland. We have done everything that the board asked us to do. We had no guidance. I had no idea that they would come back and say we had to do that other 25 feet. That completely took us by surprise. There was no indication that they wanted to see that in the revised application, none whatsoever. In fact, we had a meeting and staff was repeatedly asked, how much is enough? Never got a straight answer. Okay, I think that's it, and I'll turn it over to Mr. Wetfall. I'm sorry, are there any questions?
Yeah, Mr. Zedron, question for Mr. Priest.
As I understand this, the work was done,
Without a permit, yes, sir.
Without a permit.
Yes, sir.
Why?
I'll let Mr. Westphal address it. He had a contractor on site to do the pier. And he talked about he wanted to augment and reinforce the rubble shoreline, and the contractor said, oh yeah, I can do that. It's just maintenance, repair, didn't need a permit. The contractor did it. There was, the first hearing before the Wetlands Board was a violation hearing. The contractor was assessed a $2,000 civil charge as a result of his, and for the most part, this is, before the living, this is a common practice all over the state. If you had a rubble revetment, or a revetment that was getting out of whack, it was a common practice to recover with new stone. It was done all the time. And there was no, the additional impact, and this is what it's all about, the additional impact is 56 square feet. That's all the habitat that was lost with the removal of the ramp. That's all the habitat was lost. This was 56 square feet.
Thank you.
Thank you, Mr. Priest. Any other questions for Mr. Priest as the agent for the applicants? Thank you, sir.
Just following up on that question.
Mr. Westphal, correct?
Yes.
Okay.
I go by, you have it as Carl.
Okay.
I'm one of those juniors, so in the household, I went by Freddie. It's become Fred over the years. So I do go by my middle name, Fred Westphal.
Okay, and you were previously sworn.
Okay. Just following up on that question, our contract with our contractor from the very beginning anticipated doing the riprap. The riprap and the pier is all one deal. When I asked him, he was submitting the permit, I said, don't we need a permit for the riprap? He said, no, you're repairing existing riprap. You're putting rock on top of rock. You don't need a permit. His advisor, who prepared that first JPA, concurred with him. But as we well know now, that was wrong. But that's why we didn't get a permit. But I want to thank you for the opportunity to be here today for a second consideration of this, our third JPA. I assure you that my wife and I are very desirous of bringing this matter to a closure. It's gone on for a year, minus 43 days, and we'd like to get this phase of our life behind us. And I'm going to try to be brief, and I'll try to avoid saying things that have already been said. But I do have some points I would very much like to make. And as Mr. Priest says, we're here because one of the members of the Hampton Wetlands Board made the suggestion at the time of the site visit in connection with the second JPA, what I refer to as the Green Riprap JPA, that, well, since you're taking out that ramp, Mr. Westphal and Ms. Swift, how about putting a living shoreline in there? And while we went ahead with that second JPA, which was denied, afterwards, Mary and I said, well, that's an area that, from the cost issue, is something that we can financially deal with. From a physical maintenance issue for us 72 and 73-year-old seniors, is something that we can take care of during the initial establishment phase and certainly on a long-term maintenance phase of the living shoreline. So we decided to submit that third JPA, and it was because, as I said, we could manage it, but also we wanted to do it because we certainly recognize the value of living shorelines, and this, as I say, was something that we could do. And we felt by doing that, we were indeed being responsive to the Hampton Wetlands Board, and that we were putting in as much wetland as was possible in our particular situation. Because we had to stay away from our neighbor on the north side, because he's got a solid bulkhead revetment that we did not want to put at risk by taking the living shoreline all the way down that end. He also has a very large maple tree, very large maple tree that we didn't want to put at risk, and the mulberry tree that we wanted to retain. So we didn't want to go with a shoreline down that end. But when the suggestion was made to, well, what about putting a living shoreline where you're taking out of the ramp, we said to Mr. Priest, we're going to do that, or we're going to propose to do that, and we want you to go beyond just the footprint of the ramp and make it as large as you can on that side of the pier, so long as you don't encroach so close to the neighbor on the south side that we would put his shoreline at risk. So indeed, the actual drawings are considerably larger than the size of the ramp. Emily Hine of VIMS sent an email to the staff of the Hampton Wetlands Board on February 9th, which is part of the record of the staff report and for that hearing in February, in which she acknowledged that in the area that's shown as yellow there, that because of being in the vicinity of the mulberry tree, you would not be able to excavate upland, but you would have to fill offshore to create the grade for a living shoreline. The problem is, Mr. Priest established, I think it's been accepted, at the very beginning of this whole process, that we can't go offshore because the sediments are so fine, once you get past mean low water, they won't support the fill, the sand fill, much less the sill. So we can't go offshore, and we can't go upshore. That blue line on there of the drip line was something that I measured, and I had Mr. Priest incorporated in his drawings. That was put there as a reference point. It's not there as a demarcation line. Certainly in years gone by, it was thought that the root system of a deciduous tree, such as a mulberry tree, extended to the drip line. It's now known that the root system of a deciduous tree goes 2 to 3 times beyond the drip line. In other words, the radius of the drip line multiplied by 2 or 3. That drip line is about 25 feet. Double that, you're talking about 50 feet. That's where the pier is. Triple it, you're at 75 feet. 2 professors at Virginia Tech did research under this area, and they came up with a methodology that if you applied to that tree.
I don't believe these arguments were made at the hearing, so.
Yeah, let's try and stick to the record of what was discussed and presented at the
My point being is that the root system
Understood. I think we
extends
understand.
at least to the pier.
Okay.
So therefore, we cannot and we're not going to excavate into that area. I'm skipping forward here since I can't say this stuff. I don't know that this is in the record, but I will say that we were advised by the Hampton staff that our JPA, this third JPA, was not in the spirit of the law. And that was at a meeting in January with the staff.
Okay.
We disagree.
Yeah, so this is getting a little difficult and complicated. I understand you had several conversations with city staff, but again, this is a review of the record that the board considered, so let's try and hold it.
Then I would just conclude by saying we believe that we not only in the spirit of the law, but we are to the letter of the law.
Okay.
We are proposing to do the maximum living shoreline that we can in our specific situation.
Okay.
Is our belief. Because we were at a crossroads. It was either submit this JPA, remove the ramp, install a living shoreline, do the green riprap everywhere except where the ramp was, or alternatively, remove the veneer of the new riprap, restore the old underlying riprap. And at the end of the day, if we do that, then what do we got? We've got 112 feet of significantly disturbed wetland area because of the removal of the new riprap, and you got 112 feet of hardened shoreline. I don't think that's the objective. We think our JPA is a much better course of action.
Thank you, Mr. Westfall. Any questions for the applicant? All right. Mrs. Swift?
Yes,
Would you like, and just to confirm, you were present and participated at the wetlands hearing as well?
I have been at all the hearings.
Okay.
Yes.
Okay, go ahead.
Thank you very much.
Could you slide over to the microphone?
Yes. Thank you very much for your time and attention. This is very brief. In summary, the JPA, we have been striving for a year for a solution to a problem. The problem is something that happened, and we have to deal with the circumstances of that happening. And we have researched with contractors, with marine scientists, with persons of repute in this industry, and we have come up with what we believe is a solution to our problem. So we would like to say that the striving is over, that what you're looking at in this JPA is a solution. And we consider, and others consider who are professional, that this solution is sensible, that it is sufficient, that it is serviceable, and that it takes to account enlightened and efficient thought. All that put together, that what I just said is SSSSSWEET. Sweet.
Okay. Is that it? Okay. Thank you. Thank you, Mrs. Swift. Any questions for Mrs. Swift?
Thank you.
Thank you. Is the city represented or the board? Please come forward.
Good morning. My name's Angela King. I'm an assistant city attorney for the city of Hampton.
Nice to have you, Ms. King.
Thank you. Thanks for the opportunity to provide comments regarding the matter before you today. With respect to the denial on appeal, the board acted within its authority, followed proper procedure, and after careful consideration of all of the information before them, voted to deny the application. In reaching this decision, the board considered testimony from the applicants and their agent, as well as various other items that are part of the record, including the application, the city staff report and presentation, the VMS feedback provided in reference to the matter, and a comment letter submitted by the Chesapeake Bay Foundation. No members of the public provided comment during the public hearing. The board did fully consider the agent's analysis of the site's suitability of a living shoreline for the entirety of the shoreline, and based on a section-by-section analysis of the site, and as summarized in the city staff report, there are portions of the shoreline where the best available science does not support the installation of a living shoreline. For example, at the edges near adjacent properties and along the drip line of the tree. However, there does remain a portion of the shoreline where the best available science indicates one would be possible. This is the approximately 25-foot section on the east side of the pier. This section is not close to adjacent properties, and there is sufficient distance from upland structures to achieve the necessary grading. Additionally, VMS feedback early on indicated that the soft sediment concern could be addressed by constructing the sill closer to mean low water. And with respect to achieving the proper slope, it may not be necessary to grade landward for that full 35 feet. As noted in the VMRC staff evaluation and by previous comments, this was the third time the applicants were before the board. The board's previous denials are similar to the denial before you today. The application was denied because the best available science indicated that a living shoreline was suitable at a location where one was not proposed. For all three applications, increased costs have been cited as the main reason for not being able to include a living shoreline. The applicants did appeal that first denial to VMRC. VMRC unanimously upheld that denial. The board was even commended on upholding the law and the guidelines at that time. If today's decision is to overturn the board's most recent denial, which is based on generally the same analysis as the previous denial, additional information is requested to clarify how such a decision is consistent with VMRC's previous decision. As you're all aware, in fulfilling its responsibilities under the Act, the board must find that those three criteria are met in order to grant a permit. The main focus of today's appeal relates mainly to that second criteria, that the proposed development conforms with state code standards and guidelines established pursuant to state code. Both the board and city staff recognize that the application has improved with each submission. However, we cannot ignore the plain language of the law and the guidelines. Recent updates to state code, which are reflected in city code and the guidelines, clearly state that only living shoreline approaches should be permitted unless the best available science shows that a living shoreline is not suitable. If in answering this initial threshold question, the best available science indicates that a living shoreline is not suitable, then is the time to incorporate elements of living shorelines to the maximum extent possible. VMRC's staff evaluation references a House committee hearing regarding Senate Bill 776 and states that as a result of discussion at that hearing, the word feasible was replaced with the word suitable in order to incorporate considerations of costs. However, Senate Bill 776 as originally introduced, included the word suitable. This was not an amendment made during the House committee hearing to reflect a decision that cost considerations could be included. When the Senate bill crossed over and went to the House subcommittee, the subcommittee reported the bill to its committee with various amendments, including changing suitable to feasible and what seemed to be an effort to expand the language to include costs. During the committee hearing, there was discussion of use of the words suitable, feasible, and practicable, and ultimately the committee passed the bill with the original language of suitable. Then looking to the guidelines, again, we have clear language providing a list of different factors to use when determining suitability, all of which are physical, environmental, and hydrological characteristics of the site, and none of which are cost. The guidelines also clearly identify VMRC as the entity to turn to when there is a question about the best available science. As stated previously, in reaching its decision, the board acted within its authority as stated in the plain language of the law and the guidelines, followed proper procedure, and after careful consideration of all of the information before them, voted to deny the application. If, as a result of today's appeal, the commission reverses, modifies, or remands the decision, the city does request additional guidance to better clarify how to apply these recent changes. For example, if cost is a consideration when determining suitability, what is the threshold regarding whether or not something is too expensive? Does the threshold depend on the socioeconomic status of the applicant, the age of the applicant? Are costs meant to include just installation or also maintenance? Will the VMRC analysis regarding living shoreline suitability include a discussion of cost? Or will local boards need to obtain a separate cost estimate? And in situations where it's an after-the-fact application associated with a violation, such as today, do self-inflicted costs that exist because of the unauthorized work also need to be included? As seen by just these few examples, if cost is to be a factor in determining suitability, additional guidance is necessary for all local wetlands boards in order to ensure accurate and consistent implementation of the act. Thank you for your time.
Thank you, Ms. King. Any questions for Ms. King? A couple of questions. You were present at the hearing.
I was.
Correct? And you mentioned, and it's part of the record, that CBF submitted a letter.
They did.
Okay, was CBF present at the meeting?
CBF was not present at the meeting. They
Okay.
submitted the written comment letter.
Okay, and they submitted it directly to you all or to VMRC and the applicant?
It was submitted to staff via a Wetlands Board email, correct? Yeah.
Okay. Also, regarding your comments and concerns about cost, and I'm assuming you would be careful in how I ask this. So cost is spoken or mentioned in various cases that come before wetlands boards. Okay, and it was mentioned during this conversation, during this meeting as well?
Correct.
Okay. Any other questions for Ms. King? Okay, thank you very much.
Thank you.
Okay, sticking strictly to the record, is there anyone else that would like to comment or present before the commission regarding this case? Yes, sir. Please come forward. Please state your name for the record.
My name is Jay Ford with the Chesapeake Bay Foundation.
Please raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay. All right, so, Mr. Ford, we need to be careful. If I understand this correctly, and Mr. Nettleton helped me out, and Ms. Block helped us out as well, you did not attend the meeting?
We did not.
Just
We
yes or
submitted
no?
a
Just
letter.
yes or no? Did you attend the
No,
meeting?
sir.
Okay. Were you the author of the letter submitted?
We worked on it as a group, yes. It came out of our policy shop.
Okay. So we have a letter submitted by CBF to the Wetlands Board. It was considered by the Wetlands Board at the meeting, correct,
Yes.
Mr. Nettleton? Did CBF visit the site?
No, sir.
Okay. So what we have, just to clarify for the commission, you're hearing from CBF because they are considered a participant in the hearing due to the fact that they submitted a letter of comment on a case prior to the Wetlands Board. And let me clarify too, since this record encompasses the previous 2 hearings. Did CBF submit a letter for the previous 2 hearings?
No, sir.
So we need to be very careful in how you proceed and what your comments are on the record due to your participation. Are there any questions from the commission, first of all, and this may be from Ms. Block? So,
Yes.
Mr. Zedron.
You know, we got a thing in the law called best evidence rule, okay? And what that is let's look at this agenda, for example. The best evidence of this agenda is right here. It's in writing. There's no reason to have somebody tell you what it says because all of us can read what it says. So applying that to this situation, the best evidence in this case is the letter that was submitted by the Chesapeake Bay Foundation. There is no necessity to have somebody tell us what the letter means. We can read the letter and we can draw our own conclusions from what the letter says. We don't need somebody to tell us what it says. That's my comment.
Okay.
So, because the commission this is quasi judicial, this is an administrative hearing, the rules of evidence don't necessarily apply. I tend to err on the side of allowing things, and in the past, we have allowed VIMs to speak about the contents of their letter and answer questions and elaborate. So, I think, we're, the representative is confined, but we have allowed elaboration on letters in the record in the past.
Any other questions or comments from staff before we go forward regarding this particular issue? Any other concerns? Okay,
I will also just remind the commission, though, you all know your duty. You know that you are considering what is in the record, what was before the board. Even if something is said that was not on the record, you know that should not be the basis for your decision.
Okay, so Mr. Ford, we're going to allow you to go forward. Just be very careful about how you're presenting, and please take no offense if we stop you quickly. I do want to make one distinction. I think there is a big difference between allowing VIMs to comment when they are our duly noted in the code scientific advisor for these projects and participating in the wetlands review for these cases from the beginning. So I just want to make that clarification. I would not see or have a problem with VIMs coming to speak or clarify their comments for such a wetlands case, even though they did not attend the wetlands hearing. That's just my perspective as acting commissioner. Mr. Ford, please go forward.
Thank you very much, Mr. Commissioner, and thank you, Associate Commissioners, for the opportunity. The Bay Foundation, we followed this closely since it came before you all last September, and the reason for that being is this is really one of the first opportunities for application of your new tidal wetlands guidance that you all adopted last year. We've heard about the legislative history on that. That bill was critical. Virginia is woefully behind in our obligations to wetlands preservation here in the Commonwealth. So ensuring its application in these first trial permits was really important to us. So it's why we're here today. As we said in the letter, this is pretty clear cut. You all have statute and you have guidance. And in both of those documents, the word cost is not included. And in both of those documents, the phrase, unless the best available science is suitable or says it's not suitable, that's the phrase you have here. And so while we have all of the sympathy for the applicants, this has been a really tough permit. They've been here multiple times. They really seem like they're trying to do the right thing. But the fact of the matter is this was an after-the-fact permit that is now brought to you all and asked you to go against the verbiage in your guidance in order to help them solve an issue. And it's an uncomfortable position. I recognize that. We certainly do. And it's why the Bay Foundation has been adamant about our desire to support these applicants in installing any living shoreline. We can provide volunteers for this. Other organizations can provide funding. I believe that was in the content of our letter, sir.
Okay, okay.
It was also covered in the hearing.
Okay, sorry about that.
No, no problem. I don't want to overstep. So, but where you all stand, it's straightforward. And so we have the cost considerations have been introduced. As we heard from the city of Hampton, it is not included in your guidelines. It's not included in your statute. And the justifications for it were twofold, and that was that this project somehow falls under the economic development statute, which that's a tough argument to make, that someone's backyard is now constitutes economic development. I think the second part, the legislative history on this, that the staff recommendation includes the testimony of 2 individual legislators in a committee meeting.
All right, now that's not in your letter, and we've already heard that. So I don't think it's fair. I'm not certain that it's fair that another agency is commenting on the legislative source of this, of the wetlands guidelines.
Respectfully, 2 points. One.
Let me ask my attorney.
You a question.
Let me ask Ms. Block. We have their letter. We have CBF's letter. It's basically a page with 4 paragraphs. If CBF is going to start raising issues that were discussed at the wetlands hearing or in the evaluation from our staff, should we allow CBF to go forward with their commentary on those matters?
I mean, I think the county has already addressed that, and the county has already made their argument, and the county has participated much more extensively than CBF in this particular case. I'm trying to be generous here. You have the letter in the record. You weren't there. You didn't testify. If this was a novel argument, maybe.
May I ask a question of counsel?
There's really no. It just says on the record.
May I ask a question of counsel? I think the unique situation here is that in the staff recommendation, there was a new standard created that was nowhere in the public record. The staff recommendation recommended utilizing cost, which is not in the guidelines.
It has already been addressed. That's my point. It has already been addressed. So at best, this is duplicative.
Okay, anything else? And we do have your letter, and I think you've touched upon everything that's in the letter. And this letter was, so you're saying that this letter was created jointly by a team at CBF, but signed by Mr. Chris Moore?
Yes, sir.
Okay. Any questions for Mr. Ford from CBF? Thank you, sir.
Thank you.
Okay. Even though this is a review, an appeal of the record, if the applicants or the agent do have a rebuttal, again, based on the record, now would be your opportunity for a 2 or 3 minute rebuttal. And you don't have to come up, but if you have anything.
I understand the law, the way it's written, but I think the guidelines are flawed. They do not take into consideration situations like this. The guidelines are being stretched to fit this situation because it's not a natural shoreline, it's minimal impacts. The cost of doing what is requested is far in excess of what the project costs, and we had no indication from the board that that would be a requirement for approval.
Thank you, Mr. Priest. Any questions for Mr. Priest? I'm going to ask, did you have a question? Ms. Block to clarify the code section again for us.
So this is an appeal. We have to look for things like errors of law, unsupported by evidence, arbitrary, capricious, outside of authority. And the standard the Wetland Board was held to is the board shall grant the permit if all of the following criteria are met. 1, the anticipated public and private benefit of the proposed activity exceeds its anticipated public and private detriment. 2, the proposed development conforms with the standards prescribed in 28.2.1308 and guidelines promulgated pursuant to 28.2.1301. And then finally, the proposed activity does not violate the purposes and intent of this ordinance or Chapter 13 of Title 28.2 of the Code of Virginia. If the board finds that any of the criteria listed are not met, the board shall deny the permit.
Thank you, Ms. Block. Any questions for Ms. Block before we continue? Before we talk about a motion, I just want to make a couple of comments. This is a complicated matter. It's been a complicated matter for the past year. I am a little concerned, well, maybe more than a little concerned, that this is sort of taking on this feel for almost like a referendum on the wetlands guidelines. I understand that argument or the confusion or the question, but at the end of the day, we've got an applicant, a Shoreline, and everyone, including the applicant, the agent, VMRC, the city, the commission, is trying to do the right thing, the best thing, what makes this site better. And everyone just is going about it a different way, and we see that a lot. VMRC is our scientific advisor. They're our recognized scientific advisor, but they're not always and only the source of the best available science. I think staff did point out that the numbers generated or proposed by the second modification of wetlands creation do exceed the initial impacts. And we've heard from the agent and the applicants that they didn't get a lot of direction after going through the process with site visits in the city regarding the violation. And last but not least, specifically having worked here for the last 20 years, primarily in habitat, there is really no case or no situation in which cost is not considered. It just isn't. I realize that's difficult, and sometimes it can be an excuse why not to proceed in a certain way, but it's unrealistic to pretend that cost doesn't matter when it does, especially given the recent cost in fuel. If you try to build a house in the past couple of years, materials prices have gone sky high. There's just no way, I think, any of us, even the regulatory community, can pretend that cost does not affect these decisions. Having said that, this did start out as a violation, and that troubles me because I'm not so certain that if an appropriate riprap project were proposed here initially, it wouldn't have been approved. But we get into these situations when contractors act, homeowners act without the appropriate permits, and now we're here. This is not an easy case. It's not an easy case for the commission, and again, I don't want this decision to be seen as the commission's decision for each and every case that comes before us when there's an argument about a living shoreline. So, having said that, I just wanted to get that on the record, get that off my chest, because we've seen this for a while. We're going to see more of these. We're going to see more of these controversial type arguments and debates about what's best and what costs more and what costs less. I appreciate what Hampton has done and what they continue to do, and we hope to continue to work with Hampton. They do a good job. Ms. King, you had a great presentation. But we do, at the end of the day, have to determine if this project and what's proposed, if its benefit exceeds the detriment. So having said that, I think we are ready for a motion or more discussion. Yes, Mr. Zedron.
Discussion. I want to thank Attorney King there, excellent presentation. I think we need to look at what we're really doing, okay? And one thing we keep hearing, well, we want some guidance from you. And I want to say to the landowners here, I sympathize with your position is because all you want to do the right thing. And if you were my clients, I'd be looking at your contractor. You know, you guys are owners of property, you want to do the right thing, and what do? You go hire a good contractor, because that contractor is supposed to know what the law is, supposed to know what the wetlands law is, this law and that law, and if he don't, maybe he's got an attorney that's advising him on what the law is. But that's why you're paying him the money, just like if you came to me and were paying me to do something as a lawyer. So I sympathize with what you guys are doing. You're saying, hey, look, man, I just want to get this thing over with. I want to do the right thing. But nobody's telling us what the right thing is. So, you know, I know where you're coming from, but that's not what's coming before us. What's coming before us is a violation of the law. And what came before the Hampton situation was a violation of the law. Because I asked the gentleman here, why are we here on an after the fact? I mean, this was obviously a situation which had to put a lot of minds together to come and do the right thing. But you, in my opinion, relied on your contractor to do all that stuff. But you're sitting here before us, not the contractor. And I understand the contractor was given a civil penalty, but the fact is that you're sitting here before us and you're asking us to help you resolve this. But that's not the question before us in my eyes. The question before our eyes is, like a court of appeals, is did the department or agency or whatever you went for, did they do their job in considering all the evidence, considering what the law is? They got a city attorney over there that she's very competent. I can tell you from the way she made her presentation. Did they follow the law? And even though the decision is not in your favor, we have to determine whether they did their job. Not whether we can help you, but did they do their job? And I think they did an excellent job. The fact that the decision, and I've been a judge for 18 years, okay? Both sides can't win. This side has to win, and that side has to win. And that's what the problem is being as a judge, because you got two competent people. You got these guys, the owners here, want a good job, get it done. You got the city attorney over here saying, look, this is what this agency or department or wetlands board or whatever it is, this is what they have to follow. And the city attorney here has dotted all the I's and crossed the T's. That wetland board had done everything that they needed to do and consider everything that they needed to do. Listen to the experts over here from VMS. Listen to other people and try to come up with what the right thing to do. And the biggest problem I got is what I asked the gentleman. Why are we doing the after the fact deal? This is a very complicated thing. Instead of submitting application after application, there should have been the contractor in there going to the city attorney, going to the wetlands board, going to VMS, going to everybody to say, hey, we got a consensus on this deal. This is what you got to do, and that's it. And give you the bottom line. If it's 60,000, 100,000, who cares? This is what you got to do. You make a decision whether you want to do it or don't, and that's up to you. That wasn't done here. And so, in my mind, the Wetlands Board from Hampton, they did what they were supposed to do. And I'm sure they're sympathetic to you as well, because it's done. It's done already. And we've made some tough decisions up here about after the fact situations where we had to tell them, no, you got to tear it out. You got to redo it. And you know, so you're paying for it twice. And so, you know, absent some other comment here, I would move that we approve the action of the Wetlands Board. She has a question over.
So just to clarify, that would be to uphold the Wetlands Board decision. Ms. Lusk.
I don't have a question. I just would sort of echo what Mr. Zedrin said. I sympathize with the applicants. Frankly, I sympathized with the applicants the first time they were here, when we unanimously decided to uphold the City of Hampton's decision. Even then, I have great sympathy for the applicants and appreciate the work that they did to come up with this plan. But I also appreciate that the City of Hampton Wetlands Board, that they demonstrated they have a good handle on the law. They have a good grasp of the guidelines. If the guidelines aren't working, then I think the solution is to readdress the guidelines. But that's not what's before us today. We're still subject to this standard of review, as Mr. Zedrin so eloquently explained, that our job is simply to determine whether the City of Hampton's Wetlands Board erred in their judgment. And so I would support the motion to approve, because I do not think that they erred.
Thank you, Ms. Lusk. We're not taking any more testimony. Sorry, Ms. Swift. So we have Mr. Lusk, Mr. Zedron, is that a motion to uphold the Wetlands Board's decision? Okay, so we have a motion to uphold the Wetlands Board decision of the Hampton City Wetlands Board. Is there a second?
Second.
Ms. Lusk with the second. Any further discussion regarding the motion? Any further discussion? Okay, we'll call the vote. All in favor of the motion, please signify by saying aye.
Aye.
Any opposition? Chair votes in opposition. So
Can we see a show of hands, please?
Excuse me, hold on. Mr. Minor, you abstained. Jamie, do you have that? So that would be 1, 2, 3, 4, 5 to 1 to 1. 5 members voted to uphold the Wetlands Board. Mr. Westfall, I can't see you. 1 vote in opposition and 1 abstention.
Thank you.
Okay. Thank you all parties for your participation today. Okay, item number 8, Mike and Leah Fry. Good morning, Mr. Madden. How are you?
Good morning, Mr. Chairman, members of the commission. Get this off here. Hey, Ben, get me off here.
Oh, this is escape.
Escape?
Yeah.
All right, thanks. I'm just a couple of steps in front of an 8-track player. So.
Oh.
Mr. and Mrs. Fry are requesting authorization to construct a 36-foot long by 19-foot wide open-sided single-slip boathouse over an existing wet slip adjacent to their property situated along Monroe Bay at 543 Lafayette Street in Westmoreland County. The project is protested by an adjacent property owner. Here's an establishing shot. Winky Doodle Point, which is where Lafayette Road is the break between Monroe Creek and Monroe Bay. Mr. and Mrs. Fry currently have an 80-foot long pier, which you'll see on this photograph here in red. In yellow. They have a private pier with an L-head, boat lift, and associated catwalks. Those structures are authorized by statute and is not a subject of the hearing today. The applicant would like to provide additional protection for their boat by constructing a 36-foot long by 19-foot wide open-sided boathouse over the existing pier. The protestant's property is immediately downstream. Mr. Lloyd Rusty Curley owns that property as well as the marina immediately downstream of that. I've included this particular drawing to show that there are existing structures in the immediate vicinity of Monroe Creek and quite a few south of that as well. Mr. Curley, as in his letter dated November 4th, 2021, he stated that his opposition was based on the impact that the boathouse might have on his view and his riparian area, an impact on his riparian area. This is a plan view drawing of what is existing and references to what is proposed. The pier with the L-head and catwalk they propose a small addition to the L-head platform on the right-hand side of the boat slip. That is within the statutorily authorized size of an L-head, but the only thing is the cover over the lift. Here's a plan view drawing showing the lift. I'm sorry, it doesn't show the lift actually, but it shows the boathouse, and the boathouse is open-sided. It's 19 feet wide. There's the boat and the slip as it appeared when I was there. Nothing's changed. One thing you'll note on the left-hand side, there's an array of pilings. The ownership is, no one actually knows exactly. Those are so old, it was probably the previous owner of the downstream property. No one knows who owns those pilings, just in case you're curious about that, as I was. Something to note here is that the applicant's pier is offset, the entirety of the pier is offset 20 feet from the protestant's property line extended. In addition, the protestant is elected to exercise his riparian rights from quite a distance from from the Fry Pier, 88 feet away. He's 88 feet downstream. This is a view upstream, showing the upstream neighbor who is not protesting the project. There's the Curley Pier, and there's an 88-foot distance between the two structures. Staff has considered the protestant's concern, as we always do, regarding the roof structure and the impact as it may have in his property. While the commission staff is sensitive to the protestant's concerns, the VMRC does not have the legal authority to delineate riparian areas, so that we can't even address that. If the protestant wishes to contest this issue, then this is a civil matter that should be brought to the circuit court's attention. Staff believes that the boathouse roof proposed, had the boathouse roof been proposed and not been protested, the proposed project would meet the statutory exemption provided in section 28.2-1203A5 of the Code of Virginia. Accordingly, in the form of a recommendation, staff recommends approval of the project after evaluating all of the merits of the project and against the concerns expressed by the protestant as described in section 28.2-1205 of the Code of Virginia. Those conclude my brief comments. I'm here to answer, of course, any questions that you might have concerning the merits or any detail of the project.
Thank you, Jeffrey. Any questions? Mr. Zedron.
The pier closer to the top of the screen over there, is that a covered boathouse?
Say that one more time, I'm sorry.
Go to the pier upwards.
Here?
Yeah, is that a covered boathouse?
Not that I could tell, no, that's just a deck right there.
Okay.
But the covered boathouse is off the screen. That one that I showed you in the big, it's a little further upstream. Within sight, probably of the pier, but not.
Jeffrey, can you go back to the slide where you identified all the other
All of them?
existing-
Yeah, okay, sure. That one?
Okay,
I think
so-
that's what you probably noted.
Right.
Yeah, that's up the ways a bit. I couldn't go on that property because, of course, I didn't, you know.
So all of the other red stars?
Yeah.
Roof
The-
structures?
Yes,
Okay.
yes, sir. Those are all existing boathouses.
Any other questions for Mr. Madden? Thank you, Jeff.
You're welcome.
Is the applicant present or representative? Is the applicant present? Mr. or Mrs. Fry? Okay. Is the protestant present? Or no one's here?
No, sir.
Okay.
Just signed up.
So we have a staff recommendation. Jeffrey, one last question.
Yes, sir.
If this were not protested, it would have been an administrative approval,
Yes, sir.
correct?
Certainly.
Okay. Thank you, sir.
Under 700 square feet.
Okay, we don't have anyone here. We have a recommendation for approval. Is there a motion?
Move to approve staff recommendation.
Mr. Minor with the motion to approve, Mr. France with the second. All in favor of the motion, please signify by saying aye.
Aye.
Chair also votes aye. Any opposition? Jeffrey, please explain to Mr. and Mrs. Fry their project was approved unanimously.
Yes, sir. Thank you very much for your time.
Okay. We are now at the public comment time. I don't see anyone here except for a distinguished guest in the back, Mr. Bill Pruitt. How are you doing today?
Doing good, Mr. Chairman, good to see you.
Good to see you. You have any public comment for us?
No, thank you.
Okay. All right. So now we have our public hearing pertaining to sharks. Good morning, Jill.
Good morning. I can't remember where it is. I don't even. Oh. Is it this one? Okay. Thank you, Summers. Okay.
It's normally right here.
Is it that?
No. That's fine. We're gonna do it a weird way. Here we go. Nailed it.
Thank you. Thank you, Summers.
Millennial tech support.
All right, good morning, everybody. Before I get started, I just want to let the Commissioner and Commission know that when this was put out to public notice, the item did read a little bit different. It had 2 items in it. It also contained an item about spiny dogfish. We were going to change the trip limits, but we have since removed that item on the agenda. Staff is going to work more on that item and also bring it to FMAC before we bring it to the board. So today's item will just contain information about smooth dogfish. Okay, so for public hearing today, it's a proposal to amend Chapter 4 VAC 20-490 pertaining to sharks to update the commercial smooth dogfish annual quota. Just a little bit of background about smooth dogfish, since we usually don't bring this species to the commission. Smooth dogfish, or commonly known as smoothhound shark, is managed by the Atlantic States Marine Fisheries Commission's Coastal Shark Management Board. This board manages 40 different species of sharks. In 2013, Addendum 2 to the Interstate Coastal Sharks Fisheries Management Plan established state shares and modified the at-sea processing requirements for smooth dogfish. And then in 2015, National Marine Fisheries Service implemented Amendment 9 to the Consolidated Highly Migratory Species, FMP. And what this did is it brought smooth dogfish under federal management, and it also established Atlantic and Gulf of Mexico regional quotas. And here in Virginia, we are under the Atlantic regional quota. Virginia receives 34.803% of the coastwide smooth dogfish quota. And our state shares were established using our historical landings data from 1998 through 2010. Okay, this chart shows our state shares, the state shares of coastwide quota for 2022. You can see in the first column is the percentages. Virginia, along with North Carolina, received the highest percentages. And then you can also see the dressed weight in metric tons and in pounds. Smooth dogfish, the quota is in dressed weight. You can see for 2022, Virginia has 1,383,026 pounds of quota. We do define dressed weight in Regulation 490. Dressed weight means the result from processing a fish by a removal of the head, the viscera, and fins, but does not include removal of the backbone, halving, quartering, or otherwise further reducing the carcass. So smooth dogfish are landed already dressed, and that is why the quota is in dressed weight. Okay, here are our landings from 2015 through 2020. As you can tell right away, we do not land hardly any of our quota. Our quota was based on historical landings when Virginia used to land more quota, but currently we do not. We do, like other species, transfer to other states. In the last few years, a few northern states have asked us for quota, and we have transferred to them. We don't have 2021 up here because the landings are not finalized, but they are low as well. Okay, this is the only change to the shark regulation today. You can find it on page 14 of your eval. Section 48A, we're going to remove the sentence that addresses the actual poundage, and we're going to insert some new language that will increase regulatory efficiency. During each calendar year, total allowable commercial landings of smooth dogfish shall be limited to a quota in dressed weight calculated pursuant to the Interstate Coastal Sharks Fishery Management Plan. Staff recommends the Commission approve amendments to Chapter 4 VAC 20-490 pertaining to sharks to update the commercial smooth dogfish annual quota, and we have received no public comments on this issue. Thank you.
Thank you, Joe. Any questions for staff? Mr. Zedron?
Do you know what they use these sharks for when they catch them?
So there used to be an overseas market. Lewis, I'm gonna just.
It's used as food, in various forms. I've seen it here domestically in a meat case, and they call it steak fish. And the skin's removed. And
Lewis, could you come
We can't hear you, Lewis, sorry.
It's eaten domestically in small amounts, and probably the bulk of the catch in the years when we had a lot of landings were going overseas. And it's market conditions that really have ended up where we're just not landing much of the fish.
Okay, I got another question.
Mr. Zedron?
That picture you had up there, was that a black tip shark?
In the beginning?
Yeah, you had a shark up there at the top.
It's a smooth.
No, it's a smooth dogfish. Right there?
Yeah.
It's not
Yeah.
black tip?
No, maybe it's a bad picture.
I think that's a computerized version. That's not a photograph.
Yeah, it's a drawing, I believe.
Yeah. Any further questions? Okay, thank you, Jill.
Yep.
This is a public hearing. Is there anyone here to speak to this regulation modification proposal? Anyone here pro or con? Okay, hearing none. We do have a recommendation to modify the regulation. Chair will entertain a motion.
So moved.
Motion made by Mr. Minor. Is there a second? Second by Mr. Tankard. All in favor of the motion, please signify by saying aye.
Aye.
Chair also votes aye. Any opposition? Thank you, Joe.
Thank you.
Good morning, Mr. Gear. Still
Good
morning.
morning, Commissioner. How are you today?
Okay.
At the request of Commissioner Worrell, he asked if I'd give a brief overview of interstate fisheries management. You hear these things every day when we come in here to talk to you, but Commissioner Worrell, being new, he's been getting a crash course in this, so he asked. He's asked.
This is definitely necessary.
Yeah, so he asked if we would do this, and if the board likes, we can go into more detail. This one is like 100,000-foot level, and we'll start from there. And if the board wants us to do ones in the future, we can, where we can deal with certain, specific issues as well. Oh, I got to make that bigger. I am so sorry. Nope, the wrong one. There it is. I knew it was there somewhere. Okay. All right, let's get started. The thing about fish, they don't know what a state border is. They simply don't know. That's an old saying we say in fisheries management: fish don't know borders. And that's very clear with marine species, where a species of fish can be found off Fort Pierce in Florida over winter. It may be feeding on menhaden at the Chesapeake Bay in June and be found off of Maine, in August. So the states have to have some kind of way to manage that, for common good, so that everything works out. And we do this through interstate or interjurisdictional fisheries management. You've all heard those terms before. And there's basically two types that we're involved with. There's commissions, which manage state waters out to 3 miles, which is this little blue line along the coast. So the commissions manage from the state waters, the bay, out to 3 nautical miles. And there's 3 commissions in the United States, the Pacific, the Gulf, and the Atlantic States Marine Fisheries Commission, which we are a member of. In federal waters, they're managed by regional councils, which is, and they manage from the 3 nautical mile out to 200 nautical miles. And there's 8 of those in the country. There's 3 on the East Coast, the South Atlantic, which is here, the Mid-Atlantic, and the Northeast, New England Fisheries Management Council. Obviously, we're in the Mid-Atlantic. So, I'm going to start by talking about the Atlantic States Marine Fisheries Commission first. The commission was formed by a congressional compact in 1942, which was kind of amazing when you think about it. We were at war at the time, and they decided that they needed to do something about fishing, primarily because, you know, a lot of folks were fishing to promote the war effort, to provide food for soldiers overseas. So, but it's amazing that they were able to get all the states to sign on in this when the country was at war. It's comprised of all 14 Atlantic states, Pennsylvania, DC Fisheries, Potomac River Fisheries Commission, U.S. Fish and Wildlife Service, and the National Marine Fisheries Service. And there are 3 commissioners from each state. DC, Potomac River Fisheries Commission, and the federal government, they get one representative each. There's an administrative appointee, who's usually the head of the fisheries agency, state agency. There's a legislative appointee, who's a member of our General Assembly, and the governor appoints somebody. The thing about the commission is those 3 commissioners get 1 vote. So when we have the votes, we hope we all agree, but having an odd number, it almost assures that you're not going to, you know, have a tie, unless somebody's not there. The commission has, you know, they have a mission statement and a vision statement. The vision statement is sustainable and cooperative management of Atlantic Coast fisheries. They update this every 5 years when they do their strategic plan. And we toil over the wording on this, especially the mission. It changes every 5 years. It changes, it gets tweaked a little bit, but that's what it is now. The guiding principle is the Atlantic Coastal Fisheries Cooperative Management Act in 1993, and I'll go over that a little bit later on. And the commission is basically a forum for the states to come together and deal with issues, so and try to work those issues out, you know, usually in a friendly manner, but you know, the states are supposed to be looking out for the fish. That's what it says. We're supposed to be looking out for the better part of the fish by the purpose is maintaining abundant stocks, restoring overfished stocks, and assessing the status of unknown stocks as well. And this picture right here is from the last time we met face to face in 2009. Mr. Bowman and I are the tallest people, so we're somewhere in the back of that picture. And here is our lovely gentleman who is sitting on our commission right now. Brian Plumley is our governor appointee. Senator Monty Mason is our legislative member. Commissioner Worrell is our administrative commissioner, and I am his ongoing proxy. So just put a face with, you know, put a face with it. So there are 24 management plans, or FMPs. You've heard us use that term before, that manage 27 species or species groups. As Jill just said, the coastal sharks has 40 species in it, in the management plan. Most of the management plans are species specific though. And you can see all those species, a lot of them you've seen before. The ones with the little asterisk next to them, like summer flounder, scup, and black sea bass, are jointly managed with the Mid-Atlantic Fisheries Management Council. And the ones in red are ones that Virginia doesn't sit on. Those are New England states, New England species that we don't have any interest in. Yeah. This is just a quick flow chart of ASMSC and how it works. You have the full commission, which is the 15 members. It's 49 members total, 3 from each state, and then the other jurisdictions. There's an executive committee, which is made up of all the state's administrative commissioners, a representative governor appointee, a representative legislative appointee, and they deal with mostly policies, budgets, personnel issues, and things of that nature. Most of the work for fisheries managers is being done in the Interstate Fisheries Management Program under its policy board. And things like the Fisheries Science Program and the Atlantic Coastal Cooperative Statistics Program and the Species Board are all feeding information back into that policy board. The Fisheries Science Program is made up of just what it says. It's science programs. It's the Management and Science Committee, the Assessment Science Committee, the Habitat Committee. There's an Artificial Reef Committee. There's a multi-species Technical Committee as well. So they're doing a lot of the science work. The Atlantic Coastal Cooperative Statistics Program, or ACCSP, they collect the commercial catch and effort data from the states, and they house it in one location. And they also manage MREP, the Marine Recreational Information Program that you've heard of. So we can go on for weeks about that, but we won't do that today. The species management boards, there are 24 species management boards. Virginia sits on 21 of them. And that's where most of the work is being done and most of the decisions are being made, and it feeds up into the policy board. There are technical committees which provide data analysis and recommendations on how to move forward. There are plan review and plan development teams. If there's going to be a modification to a management plan, they have to create a plan development team that goes ahead and works on that amendment and works on modifying that plan. The advisory committees are just what they say. They're members of the commercial, recreational industry, scientists, and NGOs who come together and provide recommendations from their insight. And the stock assessments are very bright people who do the modeling, complex modeling that provide the status stock for all of our species. I did mention the Atlantic Coastal Fisheries Cooperative Management Act, and you probably recognize this gentleman here. Thank God for Ken Neal. He gives me, anytime I need a picture, I know I can get, if I said I need a picture of a tilefish, and he can provide anything I ask, he can get it for me. It is the cornerstone of the Commission's management since 1994. Before that, if the states, it was almost like a recommendation. If the states didn't want to adhere to the management plans, they didn't have to. When this was passed by Congress, the states are obligated to comply with the fisheries management plan requirements. And if they don't, the Secretary of Commerce could put a moratorium on that species in your state. And that's a big club to carry. The other two, I believe the Gulf Commission and the Pacific Commission do not have that authority. So it is a very big hammer that they can have, and it gives them the clout to be able to manage effectively. I'm going to go through this pretty quickly. It looks pretty involved, but this is their process. There's a problem. It goes before the board. They discuss it. They'll talk to the technical committee and say, can you look into this? They come back to the board, and the board says, okay, we do have an issue we have to address. So they create a plan development team that works on an amendment to the plan. That goes to the board. The board says, okay, we approve this draft amendment to go out for public comment. It goes to all the states. All the states that have an interest in that species have public hearings, and the amendments are talked about, and the public can comment. Then it goes back to the board, where the advisory panels, the technical committees, and the public can comment again before the board takes final decision. The board makes a final decision, and then the states have to adopt those requirements by the proposed implementation date. What's here in red is what happens if a state decides not to comply, for whatever reason. In some cases, it's like we can't get our legislators to get it done in time. So that's a little bit different. If some states say, we're just not going to do it, what happens is the board meets again and they take a vote, and if it's a majority vote, they find the state out of compliance. ASMSC has 15 days to send a letter to the Secretary of Commerce, and if they concur, a letter goes back to the governor of the state that says, you have been found out of compliance on this species, you have until this date to come into compliance, or the fishery will be shut down. There will be a moratorium. So we've had several states have been in this down this path before. We had the situation with Menhaden in 2019, but we corrected it pretty quickly, and so we have now the commission has the honor of managing Menhaden as a result. Moving on to the Mid-Atlantic. The Mid-Atlantic Council is like I said, it's out in the deeper waters, from 3 to 200 nautical miles. It's their driving document is the Magnuson-Stevens Fisheries Conservation Act, which I'll mention in a little bit. Their vision statement is healthy marine ecosystems and thriving sustainable fisheries and fishing communities that provide the greatest overall benefit to the nation. They meet 6 times a year. in the Mid-Atlantic states. And their guiding core values are stewardship, integrity, effectiveness, fairness, competence, and transparency. So the transparency being the public comment process that we have. And similarly, what I said before, it's the states of New York through Virginia, including Pennsylvania. It's one of the 8 regions. There's 21 voting members. There's 7 state designees, which each state is from the State Fisheries Agency. There's 7 state obligatory states, so each state has an obligatory. These are citizens of that state. There's 6 at-large seats, and there's no more fisheries. So there's a total of 21 voting members. Those 13 citizen seats, the governor anytime there's an opening, the governor of each state puts in a nominee, puts the nominations in. He has to put in at least 3 nominations. It goes to the Secretary of Commerce, and then a decision is made, and the Secretary of Commerce appoints those people. They can serve for the terms of 3 years, and if they get appointed again, they can serve for 3 consecutive 3-year terms. There are 4 non-voting members: the Atlantic States Marine Fisheries Commission, the United States Fisheries Wildlife Service, U.S. Coast Guard, and U.S. State Department. And as I said earlier, they manage from 3 to 200 miles offshore, and they have 15 species under their jurisdiction in 7 management plans, fisheries management plans. And you can see summer flounder, scup, and black sea bass are one of their management plans. And it's, as I said earlier, it's jointly managed with the ASMFC. I'd rather say that for another day if you don't mind. That would be a lot of explaining. And again, here are the members. One of the big differences, 1 person, 1 vote. So each member on that group has a singular vote, so it's not one state. So it's important for the states to have these seats filled. It's important that at-large seat, your state try to have one of those at-large seats, so you keep the voting balance equitable between the states. Captain Skip Feller is our obligatory member. Kate Wilkie is an at-large member, and I've been the state designee since last year. Okay. And their responsibilities are to develop fisheries management plans and recommends management measures to ensure long-term sustainability of mid-Atlantic fisheries. And they do this through developing amendments to the fisheries management plans, setting annual catch limits and management measures, developing research priorities, conducting public hearings and gathering public input. And all their decisions are guided by the 10 national standards that are in the Magnuson-Stevens Act. And here's the Magnuson-Stevens Act, and the best way I could put it, it's the granddaddy of all fisheries policies. It's the most important one we have in this country. It was established under the Carter administration in 1976, primarily initially to extend the United States waters out to 200 miles to get the foreign fishing fleets out. They also deal with overfishing and trying to address that as well. I already mentioned the 8 regional management councils. It's amended or reauthorized approximately every 10 years. The last one was 2006. It's been a pending reauthorization for quite a few years now. And there's the 10 standards. I'm not going to mention them all. I will just mention 1 and 2, which are prevent overfishing while achieving optimal yield and using the best data, making decisions based on the best scientific information available. The difference with the Magnuson-Stevens Act and the council is the council has to follow the Magnuson-Stevens Act to the letter. They can't deviate from that. So if it's in Magnuson-Stevens Act, they must follow it. So if Magnuson-Stevens says you're going to end overfishing within 1 year, you must do it. Whereas the commission will start that process to end overfishing. And this looks a little bit busy, but it's similar to the ASMSC where everything's feeding into a fisheries management plan. And that's the whole goal, is to keep this plan and update it and amend it as necessary. And that's done through the council committee, which is similar to the species boards with ASMFC. And these different groups, the monitoring committee are the groups that review data, do technical recommendations, provide management measures. That's similar to ASMSC's technical committee. The advisory panel has a similar role, where it's the advisory role panel in the council is a pretty dominant group. They're pretty strong, and this is for each FMP that they have, and it's industry members' recommendations that they have. The Fisheries Management Action Team, or the FMAT, is similar to ASMFC's plan development team, where if they are making a change to the plan and they're doing an amendment, they're the ones doing it. And the Science and Statistics Committee, or the SSC, are the primary technical advisors that do part of the stock assessment, determining what the allowable biological catch is, whether or not a fish is overfished and things like that. But everything's feeding into the council committee that will make the final decision on that FMP modification. I put this up here because I think it clears up a lot of what these two groups do. The jurisdiction, just showing the jurisdictions, the members, there's 49 members in ASMSC, there's only 25 in the Mid-Atlantic Council. The number of votes, the management area, ASMSC handles state waters, whereas the council handles federal waters. The number of FMPs they're responsible for, ASMSC is 24. These folks back here are sitting on numerous committees. I don't even know what the count is. I mean, raise your hand if you sit on a committee. Raise your hand if you, there you go. We sit on dozens and dozens of committees for these groups. Lots of meetings with them. Changes to the FMP are pretty much the same. It's just different wording, an amendment or an addendum versus an amendment versus a framework. And the guiding principles, the Atlantic Coastal Fisheries Cooperative Management Act and the Management Stevenson's Act are the two major ones. So, Justin had asked me, he said, can you put something in there that shows how this relates to what we do in Virginia? So assume ASMSC or the Mid-Atlantic come up with a final decision. The states must modify their regulation to comply with that approved FMP by an implementation date. They may ask for an implementation plan on how we're going to do that. States can always be more conservative than the interstate plans. They can't be less. So if a decision comes down and says you have to have a 5-fish bag limit, the states can always go less. They can't go more. So they can be more conservative. So it comes to Virginia, staff will take a look, and we know what we have to do. Let's say we have to reduce, with striped bass, we had to reduce mortalities and reductions by 18%. We start coming up with options that might do that. We meet with our advisory committees and discuss things with them, trying to get ideas that they'll endorse as well. The advisory committees that pretty much are going to do that are our FMAC, which is our Finfish Management Advisory Committee, and our MAC, which is our Menhaden Management Advisory Committee. The management committees in yellow, over here, crab, shellfish, and aquaculture, they deal with some of our state fisheries. So there may be a recommendation comes out from FMAC. Hopefully we can get some consensus between them and the staff. And then the staff will develop the changes just like Jill did, where we have the changes to the regulation we show. You get an evaluation that says why we're doing this and the purpose for why we're what's happening. And you, the board, then get to vote on it. And then once you vote, we change the regulation is then modified and amended. Just to show you here, the stars on the asterisk shows when the public comment process occurs. Every time we have a management advisory committee, we allow public comment, so the public can provide any input there. The number of times that you can comment during the ASMSC and the council process, for ASMSC for an amendment, it's at least 5 times. So on the record, if someone says they've never heard about something, usually what happens is people don't get involved until here, which is a little late. The time to get involved is in the beginning. That's when the most influence, because initially they're putting out, we need to change something, we don't know what. We're reaching out to the public to see what they think needs to be done. And so there's lots of opportunities to get involved and lots of opportunities to provide public comment. Unfortunately, what happens is always people wait until the final decision is being made. So, and one last slide. Not all of our species are managed under an interstate fisheries management plan. 2 of our biggest, blue crabs and oysters, are managed within the state. So, and there's a few other ones here. So, and that's all I had. Any questions? I was told to keep it short.
Thank you, Mr. Gear. That was much needed. Any questions for Mr. Gear? I have one comment. Is the slide previous? You may, I'm sorry, back up one more. That may need to accompany some other tasks we have in the future and some regulation amendments. Mm-hmm. I think that's helpful to remind the commission members what our duties are when these proposed regulation amendments come forward.
Okay. And like I said, if the board wants, this is just touching the surface. We could talk about stock assessments, conservation equivalency, whatever. If there's something the board wants us to bring forward as a discussion, we're more than willing to do that. Okay?
Thanks a lot, Pat.
Thank you.
Thank you very much. All right, well, that concludes our agenda for today. Finished a little bit early, which is always a pleasure. We're going to go ahead and adjourn the meeting. I'm going to change things a little bit, but I would respectfully ask that, and there's no one in the public, I don't think it's still here. I'm going to respectfully ask that everyone come back in about 10 to 15 minutes. We're expecting former Commissioner Steve Bowman to be here in a few minutes, and then we're going to honor Mr. Bowman and begin our luncheon. So thank you for the participation today. We have a whole lot more people here now than we did at any point this morning. So be prepared, this is going to take a couple hours. So, is everybody ready? We have the honor and privilege to have former Commissioner Stephen Bowman with us this morning to recognize him for his service. As you all know, Steve retired in January, and we're glad to see him back, and we want to take the opportunity today to recognize his time, his contributions, and leadership, and allow our division chiefs and others to say a little bit. I joked earlier, we want to keep this honest and brief, but not so much like a funeral where we can only say good things, but and not so much as a roast where you see on Comedy Central either. We want to keep it PG as best we can. But seriously, we do want to take some time to recognize Steve. I don't want to say too much other than just it's just remarkable. 40 years, almost 40 years of experience in law enforcement and/or the commission. I mean, just imagine that time. I don't think he was that old, number one, but 40 years, sheriff's deputy, local chief of police, Virginia State Police, deputy chief and chief of law enforcement. You were chief of law enforcement when I started. 3 different stints or commissioner under 3 different governors. That's amazing, and we really appreciate that. Everyone should appreciate that, not just those here. Anyone and everyone that's ever served in local government, state government, federal government, if you can't be just taken aback and amazed at that term, that amount of time, it's truly a credit to you and to the commission. But a couple of just quick observations of my experiences with Steve. I'm not sure how you did it, but you ran an orderly and tight meeting, and I need some help on that. I'm still trying to figure out how to politely tell people to be quiet. And you did a good job with that, but the meetings were always run carefully and properly, and with everyone watching. And it's not easy. It's definitely not easy. Another thing I noticed over our time is that you always protected and defended your staff like they were family. And I think not only I, but the rest of us appreciate that. It was rare, I don't remember it, if anyone criticized our staff that Steve didn't stand up, chest getting stuck out, you know, eyebrow raised maybe. And I'll tell you, and on behalf of the rest of our staff, we truly appreciate that. And the other thing that I've also noticed, especially in my time working in Habitat, that you respected the staff's knowledge and experience and our input, our recommendations. You listened to us, you engaged us. About 15 years ago, I think this was your first term of commissioner, we had a very contentious, controversial, sort of politically charged beach nourishment case in Virginia Beach. Seems like all those cases were politically charged in Virginia Beach, but Steve, the commissioner at the time, and I, the engineer in Virginia Beach, we didn't exactly agree as to how we were going to approach and present the project. And I remember Bob Grabb sort of in the middle of that. But the one thing I did appreciate is that even though I had a different perspective or position, Steve listened to me, he asked me questions, he asked me why I felt the way I did. And even though we did it his way, I appreciated the time, the open dialogue, and the respect. And I really appreciate that. And I think there are several stories, several people here that could say similar. So I really appreciate that. We have a plaque for you. And a gavel. Come down and read that to you as best I can. Just go Come on up, Steve. Well, first, Steve, can you bring your family up? And just
Sure.
introduce your family.
Thank you, Mr. Commissioner. Members of the commission, those assembled, it's my pleasure, and I'll save remarks for later, but I'd like to introduce some folks that are obviously very near and dear to my heart. My wife, Amy, who's been with me through the good, the bad, and the ugly up here, so I really appreciate that. My oldest son, Stephen, who's here with us. Stephen has got a pretty storied career, too. He started as a deputy sheriff when he was 18 years of age. He could actually carry a gun, but couldn't buy the bullets for it. But, and that's a true story. He served honorably with the Department of State Police and is now an assistant special agent in charge with the Department of Motor Vehicles Law Enforcement. And my other son, who is not here, but I want to say hi to him. He'll see the film later. Is toiling away at Mr. Jefferson's University as we speak at the University of Virginia. So he obviously could not be here today, but I wanted to speak and say hi to him. So my family that on my rock and my support. So.
Amen.
Okay, I'm going to do my best to read this and present this to you. It reads, "Be it known through your 25-plus years of dedicated and loyal service as a sworn law enforcement professional and the Commissioner of the Marine Resources, you worked tirelessly on behalf of the Commonwealth's marine and natural resources as exemplified through the Commission's declaration to balance recreational and commercial fishing in the protection of the habitat of the Chesapeake Bay and its tributaries. Your leadership, professionalism, and knowledge of the Virginia habitat and seafood industry enabled your colleagues on the Commission and your employees at the agency to work more effectively and with a greater sense of assurance in the arduous task of protecting Virginia's marine resources for present and future generations. You brought wisdom and a keen sense of duty, responsibility, and commitment to your work. By your strength of character and your dedication to public service, you have earned the respect and admiration of the citizens, your colleagues, constituents, and employees. We wish you the best of good health and happiness as you leave state service and begin a new chapter in your life. I am pleased to confer upon you this Certificate of Distinguished Service, former Governor Ralph Northam." Thank you very much. We also have your gavel, and it's been engraved. But I think we're going to give this to Amy. And we'll let her control it.
Please don't do that. It's been only a month, but anyway.
Thank you very much, Steve. What we'd like to do now, if we have time, is to have each division chief come up with their presentations and their gifts. And we'll start with fisheries and then go habitat, shellfish, and then law enforcement.
Thank you, Mr. Commissioner.
Thank you. Steve, I just want to say, I want to just say thank you, first of all, for what you've done for the Commonwealth, what you do for the staff, especially what you've done for me. I mean, I came here, John Bull was the one who hired me, and when John Bull wasn't reappointed, I'm like, oh, what am I going to do now? Because I hadn't started yet. But then I found out you were going to be it, and I knew you from the commission, ASMFC. I talked to staff here, and from the day I got here, you made me nothing but welcomed. When I was crawling around this building because of my back, you told my wife, anything we need, you're there for us. And I really appreciate everything you've done for me, the staff, the confidence you gave me, the support you've given the staff, and I'm very grateful for that. This is the highest honor you can get in fisheries from the fisheries management. It's one fish, two fish, red fish, blue fish. Because that's what we do, we count things. And it's signed by all the staff. Okay? And I have a fishing pole for you that the man who sold this to me told me it's the only fishing pole, the only model, and he makes it specifically, that will catch menhaden. Because recreational fishermen, he said, I want the recreational guys to catch more menhaden so they get their share of it. So,
do we have to take it off the quota?
No, there's no quota recreationally. So thank you very much. I appreciate it.
Santa Claus is coming. I'm no good doctor for
with that. My knee just popped. Commissioner, you always told me never to surprise you at commission hearings, and I think I'm going to disappoint you today. Habitat Management Division is here. I'm going to issue you a stop work order. I need to read into the record. Pursuant to Section 28.2.12.12 of the Code, I hereby certify that a substantial violation of Chapter 12, Article 2 of the Code has occurred at the following property owned by Stephen G. Bowman, situated along the Cypress Creek shoreline in the town of Smithfield. I personally inspected the site and noted the following discrepancy. The owner in question continues to work past his announced retirement and has gone as far as to sneak a call in from Puerto Rico to assess the Richmond situation, which is deemed to be an impermissible activity by his wife and VMRC. I have one more. This is, I'm going to blame on Acting Commissioner Worrell. This is a photograph of what your current pier looks like that should remain in this footprint unless you seek permanent modification.
The change, I know where to come.
He's clearly been invaluable, to all of us, not just myself, and I truly, wish you the best and hope that you might consider stop working.
I wrote mine down so I wouldn't forget to say something that I might want to say. First of all, I just want to congratulate you on your well-deserved retirement. And as one of the longest still standing employees here, my years overlapped all of your years here and enjoyed working with you the whole time. So I'm going to tell a little story about you and I. And I might ad-lib this a little, but I got my notes. But probably one of my most long-standing memories of you is when I was in the engineering surveying department and I went over to become an environmental engineer in the habitat department. I'd worked my way from Northern Virginia back down to Tidewater, like all the environmental engineers get stuck with, Northern Virginia first, pay your dues. I'd managed to get back to Isle of Wight and Surrey. My hometown and your hometown, okay? Home counties. Anyway, Hurricane Isabel came along. And lo and behold, a little village up in Surrey called Claremont had a lot of destruction of piers along the shoreline in the low area of Claremont that borders right on the James River. And me, trying to be a diligent employee, I did my research and found out that almost all those piers were probably built without any kind of authorization from VMRC in years past. And lo and behold, the land along the shoreline was not owned by the individual property owners, but was still retained by the original developer, who had long since died. Trying to figure out who owned it was virtually impossible. But I had the task of telling all these Claremont residents that they couldn't build their pier back, even though the governor said you could reconstruct stuff because these weren't previously authorized, no permit necessary piers to start with. So when I mentioned this to Steve, and Steve was head of law enforcement at that point, he hadn't become commissioner yet, he said, tell you what, Ben, how about I go up with you? That's my hometown. That's where Steve grew up, was in Claremont. Well, I was happy with that because he was wearing a uniform and had a gun. So we got in his VMRC police car. He was in uniform, as I recall. We drove up together. And this was really my first chance to sit down and have a one-on-one, kind of personal conversation. So we're in the car, for 45 minutes plus, driving up to Claremont. And I really got to know Steve then better and started a long-term friendship and relationship. So anyway, we get up there. I had set up a town hall meeting, and there were quite a few residents in the room. And I started explaining, the situation. And as you can imagine, a few people made some comments that they weren't too happy about what I was saying. And as Justin alluded to, Steve stood up like he can do. And they knew him. A lot of them knew Steve. And said, Mr. Stagg's telling you what the law is, and you have to follow the rules. And he had my back. And he had our back every time we needed him after that. And I think, as Justin said, staff really appreciate that part of your tenure as much as anything else you did for the agency. So having said that, I also want to thank you for everything you did at the agency during your tenure, running our law enforcement, being commissioner, not to mention, as Justin said, working for the Surrey Sheriff's Department, working for the Isle of Wight Sheriff's Department, State Police, Town of Smithfield Police. So to a true mentor and a good friend, I want all the best for you and Godspeed in your retirement journey. And as one last point of personal preference, I have something else I want to say. One last request for you. Even though you're retired, I want you to do one more official act before you leave. As you recall, you dubbed me the agency historian a number of times in the last 2 or 3 years you were here. And you tasked me with getting these pictures up on the wall. And with great help from Royce Bridger and even his wife, who came in last week to finish the current ones we're putting on the wall just recently because of some of Royce's health issues, he did most of the lead work to get these put up. Through our work with Michelle, you agreed to let us put a new picture up, not a plaque on your second picture. So we have that picture. The last act. I'd like to present it to you. I don't have anything you can take home like the rest of the division. But I'd like for you to go hang it on the wall officially as your tenure and your great service to the Commonwealth. Falls down, I'm gonna have to have it reframed.
Where's Michelle when I need her? That's right on your back, sir.
I'm taking your picture.
How's that me? Ready to sit down yet? I want to ask that all the representatives from the Marine Police Division come up here, along with Warner, if you would, please. Y'all come on up this way. That way you guys can look at them and not me. So, of course, I've known Steve since about 20 years. I remember when I first met him in True Value in Smithfield, but I've since developed a complex. He came to Smithfield as the chief of police, told me he was going to be there for 10. He was there for 5 and left, retired, so to speak. And then he came here. I was able to come here and work with him, and I was here 2 years, and he retired. So I told him, I think everywhere I go with him, he leaves. So I don't know if it's me or if it's him, but he says he's retired. I do believe it this time, although I do know where to find you if I need your help, and I appreciate your leadership for the past 20 years that I've known you. The man standing here before you I've learned everything I know from you. And as I said, when you left Smithfield, you were my chief there. You're also my commissioner here. So I appreciate your service.
Thank you, Colonel.
From the Marine Police Division, we have a number of things for you. One being is a very nice drawing done by MPO Hall. So if he will show that to not only you, but the public and the commission.
Oh, wow.
And then, of course, we have a shadow box that has all the badges in there, your ranks that you obtained here, a couple of our patches and so forth. So this is, so you guys can see, this is what we're presenting him.
I should have brought the pickup truck.
And I think I see Mr. Pruitt over there, and he would like to maybe say a word or two.
No.
You sure? You sure? Former Commissioner Pruitt, everyone.
Mr. Chairman, members of the commission, it's all my fault. I remember the first day he came in, he was, at that time, Chief Deputy Sheriff of Alway County. And it took me about 2 minutes to realize I had my, and the term has been used here, had my back. I knew I had somebody that had my back. And that's one of the main reasons. Of course, I had others too, but the main reason I survived was having Steve Bowman on my staff. And I could stand here and tell you some funny stories, but I'm not up to that today. I'm serious about this. Public service is a calling. It's not a job. Public service is giving your whole life to something you believe in. I watched them tearing the building down, a gang of men in a busy town. With a ho-heave-ho and a lusty yell, they swung a beam, and a side wall fell. I asked the foreman, are these men skilled, the kind you would hire if you had to build? He said, no, indeed. Just common labor is all I need, for I can easily tear down in a day or two what builders have taken years to do. I thought to myself as I went my way, which of these roles have I tried to play? Am I a builder who measures life by the ruined square? Am I shaping my deeds to a well-laid plan? Or am I content to walk to town, content with the labor of tearing down? I submit to you without hesitation or reservation that Steve Bowman is a builder, and I'm proud, very proud to call him my friend.
Commissioner Bowman, the floor is yours.
Boy, it's a hard act to follow, for sure. Mr. Chairman, members of the commission, again, thank you for having me here today. Michelle initially approached me about having something I thought was going to be a small event. Yeah, anyway, and I said I didn't like birthday parties when I was a kid, so anyway, but I'm truly humbled, honored, privileged to be amongst such wonderful people. Bill was talking about public service. You guys, you live public service as well as this entire group that's in here. Pat Gear mentioned earlier about when he was a little under the weather with his back, the discussion we had about family. Well, that's because they are all my family. Every one that you see here, as well as those sitting up on the dais, have been my family. When I came back as commissioner, I think, Ed, you were the only one left over that I knew, and coming into this as a commissioner is somewhat a daunting task. You don't know what you're going to be confronted with. You don't know the personalities. But I'd like to take this opportunity today to thank every one of you for the support that you gave me as I was commissioner. The other thing about having your back, it's not hard to have your back when you're doing the right thing. And these folks that are here are without a doubt the best staff, the best people, the hardest working, the most diligent bunch of folks that I've ever been associated with. And I have been associated with a lot of folks, as evidenced by some of the remarks about me not being able to keep a job. But all kidding aside, I would ride across the James River Bridge in the morning to come to work, and I'd look at the water, and I would think, you know, what an awesome responsibility I had, y'all continue to have, to be responsible for every drop of the water in Tidewater, Virginia, and those that run from Chincoteague to Bath and Lee and Smith County out west. It's an awesome and daunting task. And to be selected, as you have been, to sit on this commission, as have previous commissioners before, it's both an awesome responsibility and one of the biggest privileges of my life. So I would be remiss if in doing this, I know from lessons taught by former Commissioner Pruitt, I'll miss someone, but I would be remiss if I didn't thank a few people because this is extremely important to me. First and foremost, it goes all the way back to former Secretary of Natural Resources Preston Bryant, Chief of Staff Bill Leidy, and also Governor, now Senator Kane, who had the initial belief in me that I could do the job. If not for them, I would not be here today, and I know that for a fact. That was a very difficult process, a deliberate process by those making that decision, and to them I'm very grateful. I'm also very grateful to both Governor McDonnell, former Governor McDonnell, and my friend, Governor Northam, who had the confidence in me to actually call me out of retirement and ask me to come back to work. Those people were extremely important to me. The staff, everyone that you see here and those that are not here, I'd like to thank you from the bottom of my heart for the support that you've always given me, the love that you've shown, the love for each other, and the way things have gone. One special member of staff, and I would be remiss, and also those that are retired that are back here that are kind enough to come, Linda, Warner, Bill, and anyone else that might be here. But one special member of staff who's been with me and had my back and looked out for me for all these many years is Michelle Guilford. And I thank you very much. A man can't do this job alone. Through the years, my family has been, as I said, my rock, my support. And I'd like to thank Amy, who's been with me. You know, there are many mornings we would get up and have to be in Richmond for a 7 o'clock meeting, and I'm rumbling around at 4:30 in the morning, waking everybody up. And thank you for putting up with that. And Stephen, wherever he went going through the years, grew up with me in this job, and I was home sometimes and not home sometimes. And Connor, who's not here with us today, has seen me through the last term and a couple terms or whatever. If not for them, it had been a very difficult job to do. It would have been really, as Bill can attest to, without having family support in governmental service, very difficult. So with that, I'd like to thank everyone that took time out of their busy day to put this together, my division chiefs, all the nice awards. Again, Amy for having to clear out 4 walls at the house when I get home for everything that we put up. But again, I could go on and on, but y'all know me, I don't do that. It's plain and simple. So with that, I'd like to take this opportunity to thank you for the privilege and the honor to be here today, and may God save the Commonwealth. Thank you very much.
Well, Steve, I can honestly say it's truly our privilege to have you and your family here with us today. I would also like to acknowledge Michelle and her hard work for putting this together. We have a very nice luncheon planned for everyone in honor of Steve and his family today. So please join us after Steve and his family go first. I am going to ask Mr. Tankard to bless the food before we have lunch. Thank you.
Lord, we thank you for all our many blessings, for our country, for our state, for a commission that could host a commissioner such as Steve Bowman. For this, we are truly grateful. And today, we honor him. Thank you. Amen.
Please continue towards the back. All the food is in the back commission suite.